I am covering for Mr. Dyer on Delroy Durham,
Okay.
24 CF 1417, 1419, and 2412. It's my understanding they had depositions yesterday. They're just going to leave it on the next pretrial docket.
That's correct, Your Honor. We did do all depositions yesterday.
Okay, and I think today was just status to make sure
Yes,
the
sir.
depositions got
Yes.
done, but we were
Yes.
already set for the next pretrial
sir.
conference, October 29th, at 9 o'clock. Did y'all get all the depositions done, Ms. Leon?
Yes, Your Honor.
Okay. And Mr. Durham, we will see you back on October 29th at 9 o'clock for your pretrial conference. Thank you, sir. And Mr. Hardy?
Your Honor,
you Oh, I'm sorry, you had another one, Ms. Dudley.
Sorry.
I apologize.
I might be ready then.
Okay.
yeah, this is entry on Coleman at 17 CF 1004. I have received some minute discovery on it. There's some stuff I'm still missing, and I need to talk to Ms. Berrickman. So we would ask for, I think the next date is October 9th to see if I can talk to her. She wasn't here today, so about if there's an offer on this case and what the state, what the state sees in it, so.
Set for anything else right now?
No, it's just, he just has his VOP, Your Honor.
Okay. So when would you like to put that?
Can we set it on the October 9th at 9 o'clock? If possible?
That's fine for the state, Your Honor.
That way I can try to get with Ms. Berrickman about an offer.
It's my understanding she's in trial on another court right now. so-
Yes, Your Honor.
All right. Let's see, and you want that without subpoenas, correct?
Yes, sir.
All right, October 9th, 9 o'clock. All right, thank you, Mr. Coleman.
Your Honor, I did have one, I guess it didn't make the docket. Name is George Scott. It was 24
George
CF
Scott.
24 CF 2605.
2605, give me just a second.
If we can add him to the next miscellaneous, there's a motion to reinstate bond.
You want him on October 9th as well?
The earliest I can get him, Your Honor.
You filed a motion on that?
Yes, sir, I filed it, I believe, Friday.
Whose case is this for the state? Is it yours?
That's mine, Your Honor.
All right. You wouldn't be handling pretrial detentions next week, would you?
No.
I think Ms. Leone typically does them, I just want to make
yes.
sure.
But we can have someone from the state represent in that. We can have someone from the state be here for any bond motion, Your Honor.
So if y'all want to do it, so next week, Thursday, when we normally have pretrial detentions is a holiday. So it would be Wednesday if y'all want to try and put it on that docket, if y'all agree to it, otherwise it'll be October 9th.
Your Honor, if I may check the schedule in case I have depositions or something.
Because I think the only thing that we have that afternoon is a sentencing, which is with Ms. Berrickman, I believe, that afternoon.
Yes, sir.
That was a special set because of the holiday.
I'm fine, Your Honor, because it's already on my calendar for Wednesday.
What is?
The pretrial detention hearing.
Yes, that's what I'm saying. Well,
Yeah, yeah.
because it has to be Wednesday because
Yes.
Thursday's a
Yes, sir.
holiday. I just want to make sure you guys are okay with putting it on,
Yes,
putting
yes.
this motion on that date. All
Yes,
right, so
Your Honor.
what we'll do is we'll call it 1 o'clock on
Yes, sir.
October 1st,
Yes, sir.
immediately after pretrial detentions.
Yes, sir. I
All
believe
right.
that's all I have, Your Honor.
All right, thank you, Mr. Dudley.
Thank you.
Mr. Hardy, you ready now? Okay.
Your Honor, my first case is Sheena Anderson. Your Honor, at this time, Ms. Anderson's going to admit the violation. Sign it.
Yes,
And, Your Honor, it's going to be to modify her probation and community control to complete the original requirements with a $100 VOP fee.
is that for the entirety of the probation?
Yes.
All right. Ms. Anderson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name and date of birth?
Sheena Victoria Anderson, 32485.
All right, Ms. Anderson, you're here in 25 CF 820 on a violation of probation. I think we were here for a bond hearing, but you've decided to change your plea, is that right?
Yes, Your Honor.
All right. And the plea calls for you to, your probation, which it was 2 years of standard probation when you pled on June 24th, to modify that for the remainder to be community controlled to complete the original requirements, which include no contact with Carl Anderson, other than that allowed by the injunction case, no social media posts about Mr. Anderson as well.
Yes, Your Honor.
Okay, that's what you want to do?
Yes, Your Honor.
Okay. Have you gone over this form with your lawyer?
Yes, Your Honor.
And did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
All right. Are you satisfied with your lawyer's advice and representation in this case?
Yes, he's great job.
All right. Are you under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
I have depression.
Okay. Knowing that,
Yes,
are
sir.
you aware of what's going on here? And
Oh,
you're-
yes, sir.
Are you making a no involuntary decision?
Yes, sir.
Okay. And do you understand that by entering this plea that the state won't have to prove your violation of probation?
Yes, sir.
All right. And do you understand that you're waiving any potential defenses that you may have to that VOP?
Yes, Your Honor.
And what is your plea to the violation of probation? Are you admitting or denying it?
Admitting.
I'm going to accept your admission as freely, voluntarily, knowingly given. Modify your probation for the remainder of those 2 years, should be about 21 months or so, to be on community control to complete those original requirements of no contact, pay your costs of and cost of supervision and your court costs, as well as a new $100 VOP fee. I'm going to continue to withhold adjudication. I'm going to need you to speak with probation before you go back, and then you should be released today unless there's something else holding you.
We have a misdemeanor case as well, so she's not going to be released today.
It's a misdemeanor case.
It's a VOP, Your Honor. The paperwork, it took forever to get her arrested. We actually had to call and beg them to arrest her on it. Yeah.
Well, I'll be honest, Ms. Anderson. I know you don't live around here, so I don't really want to see you back in this courtroom over these same things over and over.
Yes, Your Honor.
Because I don't think it's going to go this way next time if there's another proven allegation against you.
Yes, sir. I live at home.
And, Your Honor, of course, there's no objection to her being she lives in Hillsborough, so.
Yes, you'll have to talk to probation about that to make sure they've done everything regarding that. You were already being supervised there.
Yes, sir.
Shouldn't be an issue, but I want to make sure they talk to you about that.
You also gave me permission, Your Honor, in part of the conditions of my original probation I was allowed to attend any family mediation or any other hearings, and it would not be a violation.
I don't think that's ever a violation if
I
it's
just
something
don't
you're
wanna get in
required to do
trouble.
for a court case.
Okay, thank you.
But let me just rephrase that, though.
Yes, sir.
You're allowed to go to things that you're required to for your family law case.
Okay.
But if you act inappropriately there,
No, sir.
such as, inappropriate contact with Mr. Anderson, then, that may be a violation. I can't go through all the litany of things that could be a violation or not, but
Right.
just be on your best behavior when you're at those things, which
Yes,
is
sir.
something you should do in court anyway.
Yes, sir.
All right, thank you, Ms. Anderson.
Okay,
Talk to
thank you.
probation.
Your Honor, my next case is Andre Clark. Clark is present. Your Honor, we just need to set this for a hearing.
All right, so you want an evidentiary hearing on the VOP?
Yes, Your Honor.
All right. When could the state be ready for that? October 9th, too soon?
No, it shouldn't be too soon, Your Honor.
So I have a hearing from 2:30 to 3:30, or from 2:30 to 3 o'clock that day. It's just a real quick motion to dismiss. As long as we can do it around that, I'll be fine.
Motion here?
No, well, it's on Zoom with Judge Gontieri,
Okay.
so I'll be across the street, so it won't be anything major.
That date. You said it's what time?
From 2:30 to 3, so we just say 3 o'clock.
Any issue with that, Ms. Leone?
No, Your Honor.
We've got other things set at 2 o'clock, and I'd rather not, if you're bringing witnesses, them sit around for an hour or so before we get to it. So let's go ahead and say 3 o'clock on October 9th for purposes of an evidentiary here in the VOP with subpoenas to be sent out.
Thank you, Your Honor.
All right, thank you.
That's all I have.
All right, have a good day. All right. Airfield?
Morning, Your Honor.
Morning. Who do you have?
Brandy Merrifield on behalf of John Davis. It's 21 CF 2282. Did it make it on your docket, Judge? We emailed Ms. Katie.
It didn't, but I remember reviewing it as to when
Thank
we
you.
talked about it, just didn't get onto my paper docket.
And Judge, I just need a brief moment to sign. We've already discussed this. Here, I'll bring it down here to make it easier for you. And Judge, we had originally filed a motion to set his bond. We are withdrawing that motion. We have reached a resolution, if I may approach. Thank you, sir.
So is this without a plea then?
It is, Judge.
Is it just to the one charge or both?
It would encompass all charges. However, Mr. Davis does have a failure to appear. It's my understanding the state's not going to take action, but it would resolve the case in its entirety with restitution to be determined. It's also my understanding that ASA Sheik is trying to get the final number. That's something that we've had a little bit of difficulty of. Mr. Davis has been incarcerated for, I believe, 63 days today.
Here or?
Here,
was he-
Judge.
Okay, or wasn't he in Alabama at some point?
He lives in Alabama. He was picked up at the end of July, and he's been here since then for, it was 63 days in the Okaloosa jail that I saw.
Okay. All right, Mr. Davis, you're here in 21 CF 2282. I've been handed a deferred prosecution agreement between you and the state. Did you read this form? Did you understand it? Any questions for your lawyer that she didn't answer? All right, so I'm not taking a plea. This is an agreement between you and the state to defer your prosecution. Just make sure you do everything that you're supposed to. Restitution will be reserved. Once y'all have that amount, you can certainly send that in. And you don't have to come back to court unless there's some sort of unsuccessful completion of this program. Do you understand that?
I do.
All right, so it'll be taken off the docket. Thank you.
And Judge, we have discussed the restitution issue. It's our intent to stipulate to that so that Mr. Davis doesn't have to return. I would ask that the court take no action on the failure to appear to allow his release today.
If that's what the state's doing, I'm fine with that. But Mr. Davis, this is a 4-year-old case where you allegedly failed to appear twice. If this case comes back,
I totally understand.
those things might be considered as to how the state wants to proceed with it and what the court's willing to accept. All right, thank you.
Thank you, Judge. Okay, I'll reach out to your family, okay? You're welcome. That's all I have this morning, Your Honor. Thank you.
All right, who do we have?
Hey, good morning, Judge.
Morning, Mr. Newland, how are you?
Good, sir. Isaac Newland for Courtney Scheffelbein. Ms. Scheffelbein's present. Your Honor, this is a violation of probation. We're in negotiations. We need a little bit more time. If we could possibly put it on your October 9th date and anticipate a resolution on that date. No subpoenas.
Have y'all filed a notice? I'm just trying to track how quickly these things get to the docket, because she's listed as no attorney, and I wouldn't say that about you, Mr. Newland.
Thank you, Judge. Judge, we filed it back on August the 19th, I believe.
That's why I'm asking the question. Y'all had filed that over a month ago, and I'm still showing her as no attorney, so. All right, we'll put you on do you want that with subpoenas, or is
No,
this
sir.
going to be an evidentiary? No, so I will put it at 9 o'clock, October 9th, 9 o'clock. See you back on that
See
day.
you then. Thank you, Judge.
All right, thank you, Mr. Newland. All right, I thought I saw Mr. Cobb, but he may have left. Who do you have lined up? Steve? Mr. Kleins? Mr. Kleins?
Your Honor,
Good
this is,
morning, Your Honor.
Morning.
Your Honor, this is Mr. Stewart. He is back from the hospital. There is the report. The defense will stipulate to the contents of the report, and that the court can make a determination on the competency based on the contents of that report.
You'd agree to that?
Yes, Your Honor.
I've previously reviewed the report when it came in from the Florida State, was it Florida State Hospital?
Yes, Your Honor.
And based on the stipulation of the parties that I can make the decision on this particular report, I will find that Mr. Stewart is competent to proceed at this time.
Your Honor, if we could pass Mr. Stewart to the end of the docket, we are working on a resolution here.
Okay. All right, we can bring him back once they've discussed that again. We'll see you a
Thank
little
you,
bit
Your
later,
Honor.
Mr. Stewart.
Thank you, sir.
You're welcome.
Oh, they didn't, okay.
Did they not get transported? Did they not get transported? Fell in the... You have anybody else, Mr. Klein?
Your Honor, Mr. Anderson was on today's docket for, frankly, to see whether or not he was going to accept the state's offer. I've been in sporadic communication with Mr. Anderson. If he shows up, I'll talk to him, but he's the only out-of-custody person that I have. And he's only on the docket for change of plea, so. And the other two individuals are in custody, so.
Hold on just a second with Mr. Anderson. Just, Mr. Kleins, we'll recall him and to see if he's here before the end of the day.
Yes,
I
sir.
know he's already set for another pretrial.
Correct, he's on the 27th already, so.
All right, we'll recall Bradley Anderson. Mr. Cobb?
Yes, because I'm covering for Mr. Noakes this morning on the Dandridge bond.
Okay. Do you have Lonnie Ward as well?
If you say so. Lonnie?
Lonnie Ward.
Yes, sir. Yeah, I'm covering for Mr. Noakes. I thought you said Donnie Ward, but yeah, Lonnie.
No, Lonnie Ward. I think on Ward, it was set for a plea or continuance last cycle. And then we put it for today's date and also a pretrial in October. So I'm not sure what it was intended to be for, but he's on today's docket, so.
Yes, sir.
It was for a plea, Your Honor.
It was for a potential plea?
Yes.
I know there were some things I've been putting on when we've set them for a plea. I've also given another pretrial conference just to make sure that they had one.
Yes.
For such a circumstance, if they didn't show up for today, they've got their other court date to be here for.
Yeah, I don't see him in the audience, but I will, as soon as I finish Mr. Dandridge, I'll go call him and see what's up, okay?
Okay.
Judge, this is Mr. Dandridge, State v. Dandridge in 2025 CF 756. Mr. Nopes has filed a motion for bond reduction on behalf of Mr. Dandridge. The motion is pretty straightforward and it speaks for itself. Basically, as I reviewed the record, it seems like Mr. Dandridge has a total bond amount of $25,000, $15,000 on the sale and delivery, $5,000 on the possession of a weapon times 2. He doesn't have the financial resources to make the $25,000 bond. And as Mr. Nope states in the motion, his mother could really use his help on the outside. And then I went through and looked at his arrest packet, and I didn't see any previous FTAs. I mean, I think that was scored at 0 when it came up with the risk assessment. So we're asking the court to review the bond and reduce it with the understanding that even though it's such a low bond, $25,000, it's really not low to somebody who doesn't have any money to pay $2,500 to a bondsman. And that's the situation here. I believe there's other conditions that could be instituted that would ensure his appearance at any additional court hearings, and it would allow him to get out and work and help his mother.
Ms. Leone, state's position?
The state objects, Your Honor, believes that the $25,000 casual professional are reasonable considering that he's charged with 2 second-degree felonies. He had 2 knives on his person when he was arrested. Also considering that his prior record includes battery upon person 65 years of age or older, child abuse, resisting with violence, battery on law enforcement officer, and resisting without violence. Based on the guidelines, Florida guidelines, he scores a presumptive minimum of 17.8 months DOC. The offer that the state has made for resolving this case is 20 months DOC.
The only rebuttal I would have to that is I understand that they were knives and grateful they weren't any other type of weapon like a firearm or something. And the cell charge, delivery, it probably in the end eventually be pled down to possession. That's just what I think, but it is what it is. He can't make the $25,000 bond as it stands now, and that's because his financial circumstances won't allow it. Any other defendant in a different position could easily pay the $2,500 to a bondsman, but he's basically going to be in jail because he's poor versus because that bond's necessary to ensure his appearance, which is not. He'll appear. He's always appeared. He doesn't have any failure to appear. Sir, do you have it right now? 6 months, okay.
Just so I can make a clear decision, what kind of bond is he asking for, Mr. Cobb?
Can I have just 1 second, Judge? Judges, financially, I don't think he's in a position. Well, he told me he could come up with $200 to pay a bondsman. That would be a $2,000 bond. I don't see the court doing that. So I really I don't know, but if you're lower, at least he'd have a chance to come up with the funds and possibly get out. Now you'd have to set that up with the bonds. And there's a possibility that if the court did reduce it, he could contact a bondsman or his family could, and they could work out some type of payment arrangement. My goal here today is just to give him a fighting chance to make a bond and get out instead of sitting there.
I guess my concern is, in addition, well, there was a felony case, but I mean, it was 10 years ago, but there was a battery on law enforcement, battery on a person above 65, child abuse, and resisting. And then in 22, there was another resisting. In 24, there was another resisting. These are all convictions that, you know, between the allegations in this case that he admitted that he had two different knives, and these aren't pocket knives, these are a fixed blade knife, and then also a throwing knife, as well as, according to the arrest report, his admission that he was going to be delivering this controlled substance, that being methamphetamine, to someone else. I'm not saying he should have no bond, but I
Yes,
think
sir.
the bonds are reasonable based on where they're at. So I'm going to deny the motion.
Yes, sir.
Also, the fact that there's a lowest permissible prison sentence of, say it was 18 months?
Basically, 17.8 months.
17.8.
I'll let Mr. Notes know, and then he can follow this up with any additional pleas as he seems necessary. Thank
All
you,
right,
Judge.
thank you.
All right, see you back at, oh, wait, I'm going to go call Lonnie Ward, but I have a motion to suppress hearing at 2.
Mr. Cordell Thomas, right?
Yes, sir.
Who's on Cordell Thomas this afternoon? Is it you, Ms. Leone?
Yes, Your Honor.
All right. Are we going to watch the video again?
I have it with me if the.
I've seen it, but it was months ago, so I probably should
I
review
can
it.
hand it to you now, Your Honor,
Do y'all want me to watch it during the break before this afternoon?
whenever. for
I'm
me.
afraid that if you watch it outside the presence of Mr. Thomas,
Okay.
there might be issues.
Okay. And I think I've told you this before, Mr. Cobb. I watched it when this was set. I want to say Mr. Klein's had the case.
Yes.
And I had watched it, but this was at least 2 or 3 months ago. That's why I think I need to review it again. I remember what it is, but then we'll just watch it with Mr. Thomas present.
Sounds good.
All right, thank you. All right. Y'all ready?
Yes, Your Honor.
All right. Who do we have set up? Steve, who do we have?
I can call the out of custodies, Your Honor.
Okay, go ahead and call your out of custody, Mr. Maddox.
Thank you, Your Honor.
Go ahead.
Jeffrey Baker. All right, so we finally made progress with APD this time, Your Honor.
I think you've got a couple of those today, right?
I do, Your Honor. We've made progress on all of them. On Mr. Baker, I talked to him this morning. He did complete the scheduled evaluation on September 9th. I need to reach out to the APD to actually get the report, but as of now, I'm still just awaiting the report, Your Honor. I would ask for a continuance to the October date, Your Honor.
October 9th, is that enough time?
It might be. We can do October 9th.
All right.
You
Because
okay
I don't
with
think
that?
I have anything for at least 2 weeks after that. In
Yep,
fact,
that's fine.
It would be the pretrial week, would be the next court dates I have, because the next 2 weeks are civil trial weeks. All right, Mr. Baker, we're going to see you back October 9th at 9 a.m. And hopefully I'll have that report ahead of time and can read it. All right, see you then.
Linda Blank. Your Honor, may we approach on this case? Sure.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, Ms. Blank, we're going to have you come back.
I think she's already set for 10/27, Your
Is
Honor.
she?
I believe
Okay,
so.
I was trying to look that up. All right, you'll be back on October 27th at 1 o'clock. And I'm going to issue an order. You're going to have to talk to the doctor again, a different one. Okay. All right. Thank you. And Mr. Sheik, since that's about a month out, if I can get that signed before the end of the week, maybe we'll have the report by that time.
Yes, sir.
Thank you. Just send it directly to my office with a kind of high importance to it.
Absolutely,
All
Your
right,
Honor.
perfect. Thank you. All right, who else do you have out of custody?
Yes, Your Honor. Samuel Langley. Your Honor, I have no information on Mr. Langley. He was supposed to enter a plea today.
Have you met with him since our last court date?
Met with him? No, Your Honor, but I did speak with him rather extensively outside about the plea agreement, about entering the plea agreement. In fact, he requested this day to take care of his affairs, and like I said, I don't have any additional information on him. Certainly, if I get something, I'll put it before the court, but the plea contemplated 30 days in jail anyways, Your Honor.
State?
State would ask for a capias, Your Honor.
All right, capias on Mr. Langley, no bond.
David Singleton? Our Matt Pritch?
Yes. All right, Mr. Singleton, can you raise your right hand? Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
9/7/85.
And Mr. Singleton, you're here in 25 CF 283, where you're currently charged with possession of a controlled substance, a third-degree felony, punishable by up to 5 years in state prison, and driving while license suspended, first-degree misdemeanor, punished by up to a year in county jail. Do you understand that?
Yes, sir.
All right, I've been having a plea and sentencing agreement between you and the state that would call for you to plead no contest as charged. On count one, to be 2 years of probation, $615 court costs, $150 cost of defense, substance abuse evaluation, and any recommended treatment, adjudication of guilt, which is a felony conviction, and then waive cost of supervision. Count two is going to be adjudication of guilt and time served. Is that what you want to do today? Did you go over this plea and sentencing agreement with your lawyer? Did you understand and sign it? And are you satisfied with your attorney's advice and representation? Say again. Can you pull that microphone a little bit closer to you? I can hear you, but it's close enough. I'm worried that the microphone might not be picking you up. Because usually if you speak into it, it amplifies it pretty well up here. All right, Mr. Singleton, are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues?
Nope.
Do you understand by entering this plea there won't be a trial of any kind?
Sure.
And you understand you'd be giving up your trial rights? Has anyone forced, pressured, or threatened you in any way to enter this plea?
Sure.
Has anyone promised you anything in return for your plea? Do you understand that if you enter this plea, you're waiving all potential defenses that you may have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right. And what is your plea as to the possession of controlled substance and driving while license suspended? All right, I'm going to accept your no contest plea as freely, voluntarily, and knowingly given. On count one, it's going to be 2 years of standard probation, $615 in court costs, $150 cost of defense, substance abuse evaluation, and any recommended treatment, adjudication of guilt, waive cost of supervision due to the fact that you're represented by the public defender and been found to be indigent. Count two is going to be credit for time served, adjudication of guilt. Anything that I've missed?
No, Your Honor, but I do believe the state has an announcement in 25 CF 282, Your Honor.
Yes, Your Honor. Based off of the plea and also the state not having any contact with the victim in that case, Your Honor, the state is going to dismiss 25 CF 282.
The other case is dismissed, Mr. Singleton. This is a guideline sentence. He's, based on the changes with that case being dismissed, it looks like he scored 21.4 points. Fingerprints first.
All right, thank you, Your Honor.
Oh, okay. All right, Mr. Singleton, just really quick, you talked to probation, obviously you're starting to do that already, then you need to be fingerprinted before you leave, then you have 30 days to appeal your judgment and sentence.
Brian Taylor? Mr. Taylor is present and approaching. He's before the court in 25 CF 273. Same situation here with the APD, Your Honor. He did complete his evaluation on September 9th. We are just awaiting the report back.
I'm sorry, the name again was?
Brian Taylor, Your Honor.
Okay.
25 CF 273.
All right, just, for some reason, a couple of your cases are in a different area than they normally would be in my docket, so I'm kind of flipping back and forth.
Yes, Your Honor.
All right. Do you think we'll be ready for October 9th?
I do, Your Honor, or at least I would anticipate that would be the situation. I will reach out to the Agency for Persons with Disabilities again to get a better estimate of the time frame.
All right, so the evaluation is done, waiting on the report. All right, Mr. Taylor, we're going to see you back on October 9th at 9 a.m. Stay in touch with Mr. Maddox.
And Susan Tentel was on Zoom this morning, Your Honor, hopefully this time.
Ms. Tintel, are you there? Oh, let me get that part in. Ms. Tintel, are you there? You could unmute yourself.
Sorry about that. I'm here.
All right. Mr. Maddox, go ahead.
Yes, Your Honor. So the state and I have reached a final DPA agreement in this case, Your Honor. We just finished that up yesterday afternoon, Your Honor, so I just need to email that over and have Ms. Tintel sign it, but I've already spoken to Ms. Tintel about it. She's going to sign the deferred prosecution agreement, and that should drop her off the docket, Your Honor.
Okay, well, we have to put her on something for status. You
That
think
would
it'll be
be
done
fine.
by October 9th?
October 9th, Your Honor. Can you come on October 9th?
Absolutely, yes.
Okay, and is your rehab program still going well? Just yes or no?
It's still going well, yes.
Okay, perfect.
Okay, Ms. Tintel, I'm going to have you back on October 9th at 9 a.m. However, if the DPA is filed, we can take the case off the docket.
Okay, thank you so much, sir.
All right, thank you.
All right, thanks, Ms. Tintel.
Thank you.
Give me a call.
Okay.
All right, that's all the out of custody I have, Your Honor.
All right, let me just take, I've got one more on Zoom. I've got Tony Henderson on Zoom, and that's going to be on Mr. Josie, I think it is. Mr. Henderson, are you there?
Just to get my jacket on.
You're on my video. I can't.
Judge, I'm not getting this video to work, but I'm here, and I can see you.
Well, here, let me see if that should help you, because your video doesn't seem to be turned on. There it goes. All right. Mr. Henderson, you're here on Kevin Josie, correct?
Yes, sir.
And that's 22 CF 1289. I believe from what I've seen is that we're just waiting on the report regarding Mr. Josie.
That's correct, Judge. And the information that I have from the doctor who's
on the docket that are within my part of the alphabet where counsel's not been appointed.
Okay.
That would be Destiny Hurley, Cassandra Jackson, and Casey Kemp.
All right, let me go through each of those then. Destiny Hurley, come on up.
You don't need to speak with me, I haven't been appointed yet.
All right, are you Destiny Hurley? All right, you're here in 24 CF 1658 for a violation of probation. You're not currently, don't have an attorney, is that right? Yes?
Yes, sir.
I can see you nodding. I just want to make sure that the microphone hears you. Can you afford an attorney to represent you in this case?
Probably.
Probably. Are you currently working?
Yes.
Okay. And so you don't want me to appoint a lawyer for you? I can have you fill out a form, and if you qualify, Mr.
Yeah,
Sheik.
I may be able to save you some
Okay.
time here. So the new law violation that happened here was dismissed, Your Honor. And after speaking with probation, they had recommended her just returning back to probation and dismissing the VOP.
Okay.
So at this time, the state would ask for that, Your Honor.
I was asking about the attorney. I read what the issue was as far as the violation in the new case. So what we're going to do at this point, Ms. Hurley, is the VOP, your violation of probation is being dismissed, but you're still on probation. So if I could, I'm going to have you talk to probation real quick just so they can tell you when you need to be there next. But otherwise, you won't have to come back to court for the time being. All right. Thank you, Ms. Hurley. Thank you, Mr. Sheik.
Yes, Your Honor.
I kind of thought y'all might do that, but I didn't want to force your hand. All right. And we have the other ones are inmates. Sandra Jackson, 23 CF 1180. All right. Are you Cassandra Jackson? Yes. Yeah, all right. And I see that you don't currently have an attorney. Would you like one appointed to you? Yes. Okay. How long have you been in the county jail?
Since August 4th.
Okay. I'm going to have you fill out the form, but I'm going to go ahead and appoint the public defender's office, but you have to fill out the application still. So you can get one of those in the jail, I believe.
Judge, just so that everybody's aware, it looks like there was a misdemeanor that drove this VOP. Marty, we apparently already withdrew from that because we had a conflict, and Marty Notes was appointed on it. Mr. Russell, do we need to be appointed on this and then go through the withdrawal process? So go ahead and appoint us. Cassandra, I'll have it for a minute, okay? And then it'll go to Mr. Notes, okay?
Well, it'll probably actually go to Mr. Klein's and then
Yeah,
to
it'll go to
Mr.
Mr.
Nopes if
Klein's
they
and
have a
Mr.
conflict. It seems to be a common occurrence now when there's a warrantless VOP arrest on a new law violation, they're not getting appointed a lawyer even if they have one on the new case. So I'm going to have to see what we can do about that at first appearance. Maybe that's
Yes, sir.
because I guess the VOP isn't in front of them. It's not getting done. I just don't like the idea of people being in jail for that long and not discussing it with their lawyer.
Joe, she informs me that she thinks probation's recommendation was reinstatement.
The state is not seeking reinstatement of probation, Your Honor.
Is not.
Is not.
Okay. Well, Ms. Jackson, that might be probation's recommendation. I'm not sure if it is, but the state's not agreeing with that recommendation. So, all right. So she just has VOPs in my division, the new laws in county court?
That's my understanding, Judge.
When do y'all want to Well, let's put her on October 9th at 9 o'clock, just to make sure, we're getting through the process of getting her to the right lawyer.
Thank you, Judge. We'll get that motion out. Okay?
Thank you.
Yeah, you can keep that.
Thank you. All right, are you Casey Kemp?
Yes, sir.
All right. You're here in 24 CF 1332. You're here for a violation of probation. I see, Mr. Kemp, that you don't have a lawyer. Are you asking for one to be appointed?
Yes, sir.
All right. How long have you been in the jail?
About 50 days, 40 days, something like that.
Did you come from Phoenix House?
Yes, sir. Ambulance got me from the Phoenix House, and they did surgery on me. I couldn't make it to probation. They dropped me off at a guy's house.
Okay.
But
all right, well, I'm going to go ahead and appoint the public defender to you, but you're going to have to fill out the application form.
Yes, sir.
All right. Mr. Williams?
Yes, sir. I've got okay, never mind. I'm not reading my own handwriting well. Judge, I'll enter a denial for him. I had written REC instead of RCC and thought I'd written RCC. It's just my god-awful handwriting.
Yeah. You want to put him on the 9th, or what would you like to do?
Well, Judge, it looks like I've got a note here. We withdrew conflict 10/21/24, but that would be on the case originally. There shouldn't be a conflict anymore.
On the
So
BOP.
we can do it on the 9th, and I'll go out and talk with him, talk with the state, see if we can get a resolution for that date. If not, then we can talk about setting it for a hearing.
Okay, let's put on October 9th at 9 o'clock without subpoenas. Based on what I've read and what Mr. Kemp just told me, I think we just need to take a look at it more quickly as to what the issues were.
Yes, sir.
Just for the
So we
record,
may be
the
able to
offer,
get
Your Honor, is to revoke and terminate and
resolved
42 months DOC.
42 months DOC.
That's exactly what he scores.
Okay. Well, Mr. Williams will come out and talk to you and see if there's, what your defenses are going to be and what your strategy is going to be.
Okay.
All right, thank you, Mr.
All
Hill.
right. Here, this is for you.
Mr. Maddox with your inmates.
Yes, Your Honor.
She's on the other side of the docket.
Your Honor, and I think that one was sometime before my cases are listed on the docket.
I'm sorry, I couldn't hear you.
Sorry, Your Honor. I think that one's listed a few pages before my cases.
It is.
Okay. This is Ms. Creech, Your Honor, 25 CF 1356. Your Honor, we're just awaiting the evaluation from the Agency for Persons with Disabilities. They do have all of her paperwork, so I'm just waiting for them to set up an evaluation and then give us a report.
Okay.
I did personally confirm with them that they have everything.
Was there an order on that?
There was, Your Honor.
Okay.
I had looked at it. I did not see that order in the new clerk's website. However, I did see it in the old clerk's website, which is why I reached out to the APD to make sure that everything was in order. They had the order. They needed additional paperwork, which I provided.
Just want to make sure.
Yes, Your Honor.
'Cause I think this is a situation where we were waiting on an order and to be revised or something like that. So,
I would guess they probably do the evaluation sometime in October, and then we get a report after that.
okay. So when would you like to place this?
Could we put her on the 29th, Your Honor? October 29th.
All right, October 29th for pretrial conference, 9 o'clock. Obviously, if y'all get everything in earlier, we can find an earlier date, I'll take it.
Yes, Your Honor. Just waiting for the Agency for Persons with Disabilities to come out.
Leave it at the 6 months community control. Not what she wants.
Okay, so Your Honor, this is Ms. Shannon Allman. May we approach on this case? Sure.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through
All right,
Thursday.
Ms. Allman, I've been explaining the situation about your new case, and it sounds like negotiations between your lawyer and the state. They're going to stipulate that you get a $2,000 signature bond with pretrial services. You're going to have to check in with them by phone once a week, but also you're still on probation, so you have to check in with them as they address it as well. So is the other case holding her?
I'm going to announce a no pros in that case, or a no
So that's the 20, because it's not on the docket. I want to make
Yes.
sure we've got that right. That's going to be the 25 CF 1384.
That is correct, Your Honor.
All right, state is announcing a null pros on that case.
Based on the victim's request, Your Honor.
Based on victim's request. And then it's going to be the signature bond as previously stated on the 23 CF 2805. I'm assuming there's nothing else holding you, Ms. Allman, so you should be able to bond out today. I want you to talk to probation before you leave, though. All right, thank you.
I'll double check the jail's website to make sure that there's no bond posted that I'm not aware of or something holding her, Your Honor, but I don't believe there is. And then, does Ms. Allman, would it be best for her to just meet with probation real quick and
Yes,
get her a date on the books to check in with?
I just asked her to do that.
Okay.
As far as the jail is showing, this seems to be the only thing holding her.
Okay.
Well, it looks like she was released on bond on the new case.
Okay.
So she should be released today regardless. But Mr. Sheik, if you could make sure, or I'm sorry, if the clerk could make sure to indicate that the other case was dismissed. Thank you.
All right, thank you, Your Honor. And then her next court date.
Oh, I'm
Your
sorry,
Honor,
yeah, I forgot about that. October
10/27.
10/27.
All right, well, the 9th.
It's a VOP.
Yes, the
Let's
9th
go
is fine.
October 9th at 9 o'clock. Ms. Allman, I just want to make sure you hear this. Ms. Allman, it's okay. I didn't set you a court date. You're going to come back in a couple of weeks, October 9th, 9 o'clock. All right. All right, go ahead, Mr. Mavericks.
Your Honor, this is Ms. Caitlin Bramble for the court in 25 CF 159. Your Honor, she has met with the Agency for Persons with Disability in the jail. I'm not sure what date that was, but it was sometime in September, Your Honor, and I am awaiting the report.
You want to put it on the 9th?
The 9th, Your Honor.
Just like the others? All right, Ms. Bramble, you'll come back October 9th at 9 o'clock. Mr. Maxis, send me a courtesy copy of that report once it comes in. Thank you.
Yeah, I can provide you one, certainly. in the next month or so. 2 weeks, well, 2 weeks, yeah. October 9th is the next court date. At 9 a.m.
9 a.m. Thank you.
Your Honor, this is Mr. Shamar Anderson before the court in 22 CF 2184 and 23 CF 2417. Your Honor, it's his first time up. I'd ask for a continuance.
State. Objection to the continuance or any? You want to continue it without subpoenas for the VOP?
Yes, Your Honor.
State would request setting this for a VOP, Your Honor, hearing.
This is his first time up, Your Honor. He's still mulling over his options.
When do we want to set?
I would just propose the pretrial conference date, or October 9th, whichever the court prefers.
I don't really like putting VOPs unless they have new charges on the pretrial conference date. I like to keep them on the miscellaneous date.
October 9th 's fine, Your Honor.
Okay. With subpoenas?
Without would be defense's request.
We'll be fine without subpoenas for October 9th, but we'll be
2
asking
weeks,
for
but after-
it if we don't come to a resolution then, Your Honor.
Understood.
All right, Mr. Anderson, we'll see you back in 2 weeks, October 9th. And if there's no resolution at that point, it'll be set for a hearing.
Understood. Your Honor, this is Mr. Louis Osty. Louis Osty before the court in 20 CF 2783. Your Honor, I had emailed a counteroffer to Ms. Berrickman after talking to Mr. Osty about it. I am awaiting her response. She's in trial currently. If I could get the October 9th date on a continuance, Your Honor.
Your Honor, if I may, the offer extended by Ms. Berrickman is to revoke and terminate with 48 months DOC and cost of transportation.
All right, but Mr. Maddox, you said that you had given a different offer back to Ms. Barrett?
I had emailed a counteroffer, Your Honor. He scores, my understanding is 36.450 points, so I had made a counter after talking with Mr. Osty about that.
All right, Mr. Osty, we'll see you back in 2 weeks. Obviously, there seem to be a negotiation still, and your prosecutor's in a trial in another courthouse.
Yes, Your Honor.
October 9th, 9 o'clock.
Your Honor, this is Mr. Lynn Banks before the court in 22 CF 2873. Your Honor, Mr. Banks is still considering his options, and I did inform the state that he got into a rehab program, Chrome. I do believe the state is somewhat open to considering that still, Your Honor, so I would ask for one last continuance in this case without subpoenas.
State is fine, but if we could do October 9th, then we'll be setting it at that point.
And that's understood, Your Honor.
Okay. Mr. Banks, we're going to set you for October 9th at 9 o'clock. If there's not a resolution at that time, you'll be set for an evidentiary hearing.
Yes, sir.
All right, thank you, Mr. Banks.
Can we approach on Mr. Kane, Your Honor?
Sure.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3.
All right, we'll reset it for October 29th at 9 o'clock for Mr. Kane with an evaluation to come.
And I'll get an order to the court, Your Honor.
Thank you.
Your Honor, this is Mr. Klein before the court in 22 CF 1153. Your Honor, I would ask for one last continuance to October 9th without subpoenas. I had just spoken to Mr. Klein about the state's offer. I reached out to the state. Their offer is consistent with his suspended sentence. It's 36 months, so that is the offer they've made to him. He's still mulling it over, Your Honor, so like I said, I would ask for one last continuance with the understanding that it'll be set for a hearing if we don't reach some sort of resolution.
That'd be fine, Your Honor.
And then I believe Mr. Klein wants to address the court, and I've already spoken to him and advised him on what to say and what not to say, Your Honor.
Hold on just a second, Mr. Klein. I just want to announce this. You're going to come back on October 9th, 9 o'clock. If the case isn't resolved at that time, it's going to be set for an evidentiary hearing. Go ahead.
Here. Go ahead.
You don't want to take me long.
That's fine.
Your Honor, if I may, could it be placed under oath?
Mr. Klein, can you raise your right hand? Do you swear or affirm any testimony you give here today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Go ahead, Mr. Klein.
Well, yesterday I said something about a bond hearing, but I know it has to go through him. I wanted to let you know that I'm not a flight risk. I don't have any FTAs. I'll even take the GPS monitor and pay for it if I have to ensure you that I'm not going anywhere. I've been incarcerated here for 100 days now because of a technical violation of probation for fines and community service, all of which I could take care of within 60 days if I was given a bond. Your Honor, I've lost everything since being in here. My car, my wife has just lost our apartment, is now headed back to Crestview to live with her parents. I've even lost my phone service. I called Okaloosa County Sheriff's on June 18th and turned myself in. You guys didn't have to come get me. I came all the way from GA to take care of the warrant. I checked into Muskogee County GA probation every month I was there and wasn't contacted by Florida not once. Everyone knew where I was there. Had I known that I owed Florida still while I was in GA, I would have paid and did my community service. I'm just begging you and the state for at least anything I can get.
We're not here for a bond
not-
hearing today, Mr. Klein.
I understand that.
So if the motion's filed and set for a hearing, I'll consider it, but the state is entitled to notice of any kind of bond hearing.
Yes, sir. And that's
But I'd
all I
also
had.
point
I'll
out,
be
part
able to
of
get
your
back to-
violation includes that you didn't complete a treatment evaluation. It's not
Yes,
just
sir.
financial or community service.
Yes, sir.
October 9th, 9 o'clock.
Yes, sir.
Thank you, Your Honor.
Thank you.
Thank you, Mr. Klein.
You said it was an Abbott.
Thank you, Your Honor.
Thank you.
Your Honor, this is Mr. Tyler Webb before the court in 25 CF 253 on an uncontested motion to withdraw a plea, Your Honor.
And Mr. Webb?
Yes, Your Honor. Mr. Tyler Webb. And if we need to, Your Honor, we can pass him to the afternoon.
I just don't think he was on my paper docket.
I had him on mine, Your Honor, and I did email Ms. Guzman about it and stayed in touch with her.
Okay. I'm not trying to,
No, and I want
mix
to,
up anything, but as far as, did you contact the clerk to have him put it on the docket for today?
contact the clerk, Your Honor?
Yes.
No, sir, I did not.
Okay, typically the clerk is who puts these types of things onto the docket, so I think that might be the confusion.
Okay.
But, so it's a motion to withdraw a plea?
Yes, Your Honor, it's uncontested. I do have a copy if the court needs it, and then again, we can pass it to the afternoon if the court wants to review it.
Just have to look at it because I didn't see it on my docket yesterday.
I appreciate that, Your Honor.
I know there's some late add-ons and removals, but maybe I just forgot to check that last email.
And that's understandable, Your Honor. And I'll CC the clerk on any future add-ons.
All right, so the intent is to have him withdraw his plea and enter in a new one just with different conditions based on, sounds like some contact with the victim in the case as well as some language about ECLC that has to change.
Correct, Your Honor.
And also, no, there is also a major change. The count 1 and 2 is not, was as charged. The state has agreed to a lesser included simple battery.
That's also true.
On 3 and 4?
On
No.
the battery on law enforcement
Yes, on the
count.
battery on
Battery on law enforcement.
Yes,
Correct.
Your Honor.
So count 1.
Correct.
Based on the stipulation with the state, I'll go ahead and grant the motion to withdraw the plea. I still think we need an order on that, Mr. Maddox,
I'll
even if
I'll
he's going
send
to
one
enter
over.
a new one, I think just to make sure again that it's clean.
Yes, Your Honor. And then I have his signed new plea if the court would like to take it today. All right, may I approach?
But the score sheet.
Attached, the
Yeah,
one
yeah,
you
yeah,
reviewed.
yeah,
Okay.
no, that's.
And it looks like it was emailed, so.
Okay. Well, never hurts to improve on my end either, though.
This is my understanding that things were added and the docket was updated as of yesterday afternoon. We waited until pretty much the end of the day, and I assumed everything was on it, but you did email it to my office on the 22nd, so that's on me.
Okay.
All right. All right, Mr. Webb, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your name and date of birth, please?
Tyler Lee Webb, March 8th, 1998.
Okay, Mr. Webb, as we've discussed, you're here in 25 CF 253. I just granted the stipulated motion to withdraw your previously entered plea, and now that it's withdrawn, you want to enter into this new plea, is that right?
Yes, Your Honor.
Okay. And you're currently charged with battery on a law enforcement officer, resisting without violence, and 2 counts of felony battery. Do you understand that?
Yes, Your Honor.
All right, and the new plea and sentencing agreement calls for you to plead to a lesser included of misdemeanor battery on count 1 statute number 784-03-1A1. It'd be adjudication of guilt and time served. Count 2, the resisting without violence, adjudication and time served. And then counts 3 and 4 would be withhold of adjudication, 11 months, 29 days probation, concurrent between those two charges. Special condition, you do 11 months, 29 days in the Okaloosa County Jail with credit for all time served, beginning as of September 2nd. And that you comply with the ECLC program, and your probation will automatically or shall terminate upon your release from jail. Also, $967 court costs, $150 cost of defense, waive cost of supervision, since you're basically going to be in custody during the entirety of your probation. Is that what you want to do today?
Yes, Your Honor, it is.
Okay. And have you gone over this plea agreement with your lawyer?
Yes, Your Honor.
Did you understand and sign it?
Yes, Your Honor.
Are you satisfied with your lawyer's advice and representation in this case?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
They're getting much better, Your Honor.
Okay. Do you understand what's going on here today, though?
Yes, Your Honor.
All right, you seem to be tracking everything that I've
Yes,
said. I just need to ask that question based on your answer. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
And has anyone promised you anything in return for your plea?
No, Your Honor.
You understand by entering this no contest plea that there won't be a trial of any kind?
Correct, Your Honor.
And do you understand that you're giving up all your trial rights, which are listed on page 2 of the agreement that you signed?
Yes, Your Honor.
You understand you're waiving all potential defenses?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, Your Honor.
All right. And what is your plea as to the reduced count of count 1 to misdemeanor battery, resisting without violence, and 2 counts of felony battery?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. On counts 1 and 2, it's going to be adjudication of guilt and time served. On counts 3 and 4, I'm going to withhold adjudication, so there won't be a felony conviction. 11 months, 29 days of administrative probation, concurrent with the special condition that you serve 11 months, 29 days in the Okaloosa County Jail, with credit for all time served beginning September 2nd, 2025. That's concurrent between 3 and 4. Comply with the ECLC, or Emerald Coast Life Center program. Your probation will terminate automatically upon the release of your release from jail. As far as the court costs of $967 and $150 cost of defense, we'll send those to judgment and waive cost of any supervision. All right. Anything that I've missed?
No, Your Honor.
No,
I
Your
appreciate
Honor.
it.
All right. Thank you. I'm going to have you talk to probation. I'm not sure they're really going to supervise you. And I do need you fingerprinted because there is a battery conviction.
Okay.
Did we get it? Well, are we just going to?
It was an adjudication last time, so
I just worried that the date's going to be different and it might get confusing. Because technically that plea was withdrawn. He should probably just out of
No objection from defense.
better side of caution, I think is. All right. Mr. Cobb, he had Lonnie Ward, I think.
Jason Cobb on behalf of Lonnie Ward. I talked to the state. Can we leave it on the October pretrial? We're going to talk about a plea and get it worked out if we can, and I'll advance it on the docket.
I'm fine with that, Your Honor, please.
Okay, and he knows to be there on the October date because I've already assigned it last time, right?
Yes, sir.
Okay. Obviously, if he doesn't show up for that, he's going to have a KPS.
Yes, sir.
All right. So that's October 27th at 9.
Yes, Your Honor.
All right, see you back at 2.
All right, thank you, Mr. Cobb. That was Lonnie
Judge,
Ward.
you did have one other person out of custody that was not on the published docket, but we got him added on yesterday. We'd done a notice of hearing on it. Mr. Calbo had filed with the court a written letter indicating some dissatisfaction with my services. I spoke to him a couple of minutes ago. I don't know that he still wants to go through with that, but I think the court needs to inquire and get an answer on that.
All right. Can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your name and date of birth, please?
Isaac Calbo, 01/24/1993.
Okay. And Mr. Calbo, I think you sent some correspondence into the court back on, well, it was received at least on September 3rd, right?
Correct.
All right. And what are you requesting from the court?
I didn't entirely know. I just felt like reaching out to you personally because I felt like even though this...
You can't do that. That's the issue.
I didn't know.
Anytime someone sends a letter to me, it gets sent to the parties and it gets put in the court file.
Gotcha. But, even though this case has drawn on for quite some time, throughout the process, I've had 3 different defenders, 2 judges. I'm just not sure. I don't see...
What are you asking me to do?
I don't know if changing representation will help, but I don't.
Well, the only way I can potentially change your representation is if you tell me that he's done something that's been detrimental or ineffective on your behalf. You can't just say I want somebody else.
That's fair enough. So I guess I don't want to waste your guys' time. So I guess nothing.
You don't want to go forward with anything to remove your lawyer?
I don't think he's done anything detrimental. No, I wouldn't say that I could.
To me, it sounds like you just don't like how things are going at this point.
A little bit, yeah. And I don't know. Like I said, I don't know if different representation would even help at this point. I was just trying to do everything I could from my end to get something effective to happen.
Okay, and you're always able to hire private counsel if you'd like, if you've got concerns that maybe that could help.
Unfortunately, I don't have.
I can't say what it will. I don't even know where you guys are at with your negotiations. Right. As far as me being the second judge on your case, those rotations happen every 3 years.
Right.
So I'll be here until the end of 2027, and then it'll rotate to somebody else most likely. So
okay.
It's just you just happen to have your case pending when that happened.
I got you.
All right. So what are we going to do with Mr. Calbo?
Well, Judge, that was all he was set for. He's still on the docket for 10/27 at 1 p.m.
Okay. All right, Mr. Calbo, we'll see you back October 27th at 1 o'clock. Stay in touch with your lawyer and obviously consult with him as to what y'all want to do on that date.
Thank you.
All right. Thank you, Judge. Judge, there's one other matter I wanted to bring up. He's not on the docket for today, but the state and I took depositions and as a result have reached a deferred prosecution agreement in a case. His name is Jeremy Dustin Holly. It's 4625 CF 1021.
It's not on the docket, though?
It's not. I'm asking to add him on this afternoon. He's already signed the DPA. State signed it. I've signed it. Once we get him in, he'll be able to get out of jail.
Oh, he's in jail. Okay.
Yes, sir.
I was wondering why we needed it back on the docket then. All right.
That's why.
All right, can we see about having him transported for 2 o'clock?
It's Jeremy Dustin Holly.
All right, thank you.
And if you... All right, Judge, I'm ready for the rest of my case.
Mr. Russell's sneaking in.
I have one out of custody, Judge. William Ewing. Mr. Ewing is present and approaching. Case number is 24 CF 569. Judge, I filed a notice of competency hearing for today. We got the third evaluation.
I hadn't seen the third one. I know I've seen the other 2.
If you look, I looked on the new clerk's website. Dr. Salinas filed it directly with the clerk. 9-4 is what I saw.
I didn't realize that the doctors could do that. So from my memory, there was one that said he was competent and one that said he wasn't.
That's correct, Judge.
Okay. And the newest one that was filed by Dr. Salinas on September 4th says that he thinks he's competent.
Correct, Judge.
What do y'all want to do today?
So defense would just ask that the court make a finding on Mr. Ewing's competency, and then we would set it for the pretrial conference on 10/27.
Mr. Sheik, state's position?
No objection from the state on that, Your Honor.
I'm reviewing the newest one. I apologize, I didn't check the other website to see if it was there, but I've previously reviewed the other two reports in Mr. Ewing's case. Showing that Dr. Salinas has acceptable as to every single factor, and opines that he's competent to proceed based on the parties' agreement to go forward with this. I'm going to go ahead and find that Mr. Ewing is competent, and we'll set him for the October 27th date at 1 o'clock. All right. Okay. What was that, Mr. Ewing? Okay, I thought you had said something. All right, we'll see you back on that date. Stay in touch with Mr. Russell.
Thank you, Judge.
Thank you, Your Honor. You have it? Howell?
Howell.
Oh, yeah, go. Yeah, I'm going to move that for you.
Thank you, Judge. This is Bobby Howell. He's got 3 cases before the court. Judge, I'm going to enter denial for him today, and then I have advised him I'll go back out, go over the offer in more detail, and we'll discuss what we're going to do from here.
So when would you like it set and for what?
Well, I'd like it set without subpoenas.
Okay. October 9th?
Yeah, that'll be fine, Judge.
Yes, and I just want to announce for the defendant that the offer that I sent out in discovery is going to be modified to be better for Mr. Howell, because I just spoke with probation. She has some information that she needs to share with me, and then we will modify the offer.
All right, so it looks like it's going to get better, okay?
Oh, Your Honor, can I ask you a question?
You might want to run it by your lawyer first.
Yeah, I do. Well, he wouldn't have it yet, but I have copies of it, but I would not provide evidence to a judge. Okay.
I was just trying to see.
I don't know what you're talking about, Mr. Howell.
Judge John Smith from the 23rd Judicial District of Ascension Parish, Louisiana, emailed some information of my status of things I've been doing in the state of Louisiana to you.
Okay, but I'm not making a decision on anything today, so I don't review evidence in the case.
Yes, sir.
Unless I'm asked to do so, and I'm actually making a decision in your case. I mean, if we get to a sentencing hearing and that's relevant to your sentencing, I'll certainly take a look at what you have, but typically judges don't talk to each other about their cases.
Yes, sir.
All right, thank you.
Okay.
And October 9th, 9 o'clock, no subpoenas.
Thank you.
All right, thank you.
Okay. Judge, state's just made an offer I need to go over with Mrs. Hutchinson, if I can pass her till about I've got another guy coming in at 2 p.m., as the court knows. If I can pass her until 2 p.m. as well.
All right, Ms. Hutchinson, you're going to have to stick around. So we'll see you back at 2 o'clock.
Yes, sir.
All right,
Thank you. Judge, this is Mr. Johnson. I'm still in the 19 CF 2000. I'm still in the process of negotiating with the state, and we did have an evaluation, mitigation evaluation done, and I sent that over to the state. That'd be Ms. Barrickman. I don't know that she's had any time to do anything with it, so I'm going to ask to pass it out again without subpoenas.
She only, Your Honor, if I may, Ms. Barrickman indicated that they're continuing the case to see if he's accepted into the REAP program.
That's one of the other alternatives, Judge, and he's amenable to that, either REAP or Phoenix House. That came about as the result of mitigation, so maybe not the 9th, maybe a later date out.
That'd be fine, Your Honor.
I just hadn't heard of the REAP program, that's why I asked.
I think it's in Pensacola.
It's in Pensacola. If you remember, oh gosh, I can't think of his name now. He was, at any rate, it's a good program. It's sort of designed for folks in his situation.
My next miscellaneous date after the October 9th date would be October 30th.
That'll be fine, Judge.
October 30th, 9 a.m. for the VOP without subpoenas.
All right, thank you, Judge.
And obviously, if y'all work something out and we can get into an earlier date, I'll certainly take a look at it.
Yes. Judge, I've met with Ms. Kagaris a couple of times. This is Stacy Kagaris, 25 CF 981. I'm going to ask, see if I can get an expert to do a mitigation, another evaluation on her, and see if I can get them to help me out with this case.
I'm okay with the continuance, Your Honor.
I'm going to suggest the 30th, Judge.
All right, October 30th, 9 o'clock, no subpoenas.
Thank you, sir.
Thank you, ma'am. Do we have a Rebecca Owens for you, Mr. Williams?
Rebecca Owens, she was not transported over. Rebecca Owens, 24 CF 2603. She's in the Walton County Jail undergoing a treatment program over there. I'm just going to move to continue her case. It's a 120-day program. I think the state's offer was a year in county jail. I'll go out to the Walton County Jail to talk with her. But for today's purposes, I'm going to ask to continue it.
What date?
Judge, again, it's 120. I'm going to say 10:30. I don't see any point in trying to bring her back for 10:09.
Okay, October 30th at 9 o'clock.
Thank you, sir.
This is Mr. Russell with Mr. Atkins.
Thank you.
Mr. Russell, you said he has two?
I have, Judge, this is going to be Herbert Atkins. Case number for the record is 2007 CF 622. On Mr. Atkins' case, Judge, we're waiting for an evaluation. I checked with Dr. Zeman's office this morning. We should get a report shortly, so I'm asking for a continuance to October the 9th, and then we can figure out how to proceed on the case. Did you hear that?
You have to talk in the microphone
I'm
for
sorry.
that.
Mr. Atkins, I checked with Dr. Zeman's office. They're working on the report. We should have that shortly, so I'm asking that we put it on October the 9th, and by then, if we get the report, we can figure out what we're doing with your case, okay? Yes, sir. Couple weeks out. Okay. Okay.
So the evaluation's been done, you're just waiting on the report.
According to his office, Dr. Zeman has already met with him. He's just got to prepare a report.
Gotcha. All right, October 9th, 9 o'clock.
Okay? We're coming back October 9th, okay? A couple of weeks. Okay. Judges, this is going to be Joseph Carroll approaching case numbers 2024 CF 2383. Mr. Carroll had filed a motion for Nelson hearing on September the 19th, so I set it for hearing today.
Mr. Carroll, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth, please?
Joseph Carroll, 128, 1989.
Okay. Mr. Carroll, I've read your one-page motion stating that you think your attorney has a conflict. What would you like to tell me about that?
I placed a civil lawsuit against him in the public defender's office.
Okay.
So.
And what's the basis for that?
In my opinion, it's just my opinion, he wasn't doing his job and we was constantly arguing about stuff.
What do you think he's done wrong?
I mean, the fact that the last court date, he told me, he goes, well, they got new evidence against you or whatever. And come to find out it's the same stuff that they base their whole arrest off of. And it's just like one thing out of nowhere, always arguing every time he comes to visit me.
Okay. About, do you want to tell me what about? Because I don't see it. Did you file hold on a second. Let me stop that one real quick. Where did you file the civil lawsuit?
Through Maria Maddox.
And where is it filed?
She's out of Tallahassee.
I know where she's out of. Where is it?
I don't know where she's filing it at. She's the one I'm going through.
Okay. Have you retained her?
Yeah.
But you don't know where she's going to file the civil lawsuit?
I haven't. We don't.
I don't see it filed.
We only communicate through mail, so the only way she wants to communicate is through mail.
I just don't see a civil lawsuit that's been filed. And that's the only thing you put in your motion.
Well, that's what because I sent it in to her because I've already been discussing everything with her. And she sent me the information to fill out to send back to her for the lawsuit. So that's what I did.
But at this point, all you've told me as far as why you don't want him as your lawyer is because you guys argue.
It's just like a lot of the stuff that we discussed as part of the lawsuit. Because it's just, to me, it feels like he's throwing me to the state because we discussed a lot of stuff, and I'm not going to discuss it in here because it's part of my defense. And,
I understand that, but just saying you guys disagree or have an argument without more, I don't.
well, I mean, I'm not gonna be sitting there and told I'm stupid, pretty much, and just constant bull crap out of him. We're always arguing, can't get along, and he's lied to me and admitted in court that he lied to me, and nothing has been done about it.
When did he admit he lied to
The
court?
the last Nelson hearing we had.
Mr. Carroll, I have about 800 criminal cases.
That was
And
back
so
in
I don't always have,
Ju- back in July 10th.
hold on. I don't always have independent recollection of each, case, especially if it happened months ago or something like that. So when was that, do you think?
July 10th.
July 10th. And what are you claiming he lied about in court?
Because he had told you that he told me he was gonna bring the stuff to me and never did.
All right, so he said he was going to bring you something and he didn't do
Yeah,
that.
and then he said that the state didn't turn over the phone call, and then he told me, then in court, he's like, well, that's not true. They did.
Russell?
We did eventually get the jail phone call that he's talking about, Judge, and I did go show to him. Lying's a pretty strong term. I don't know that I lied to him, but that's my opinion.
All right, so just so you understand, Mr. Carroll, lying really includes an intent to deceive someone, to trick them or something like that. Being mistaken or not living up to a promise potentially because of other circumstances doesn't really get to the point of lying. So I'm just not quite sure what you're claiming he's done.
I don't see how where you tell somebody you're gonna do something as simple as just handing it to somebody to bring to the jail. There's any circumstances that.
Have you seen what you're referring to or heard what you're referring to?
After the Nelson hearing.
Okay. So, but that situation.
And then when I brought
Mr.
up.
Carroll, I'd appreciate it if you don't interrupt me when I'm trying to tell you something. There's two reasons. Number one, I'm trying to have a dialogue with you, and I need to be able to have my side of it too. But second, everything in this room is recorded. And if we talk over each other, then the recording becomes kind of muddled. And if you need a transcript of this one day, you want to make sure it's clear. Okay. So you brought it up, and he's fixed the situation, right? He's given you, I don't want to say show because it was a phone call. He's let you listen to the phone call, is that right?
Yep.
Yep.
Yes, sir.
Okay. So what else is the problem?
I mean, the fact that he thinks that he could talk to me any kind of way when like I asked for, because you said that if after we listened to the phone call, I felt like bond reduction or whatever, that I can apply for it, that you would entertain it. Well, when I brought it up this last time to him, he got pissed off. Sorry, Your Honor. He got mad and raised his voice, started yelling at me about it. I'm sorry, but I'm a grown man, and I'm talking to you like a normal human being. You can talk to me like one.
Are you talking to me or about Mr.
About
Russell?
him.
Okay, I just want to make sure it's clear.
Oh, no, you're talking to me like a human being.
Oh, I understand.
But-
Well, because that's how I certainly try to talk to everybody. It's just when you were talking about him, then you started saying
Yes, sir.
you,
I'm
and I was tracking it. I just wanted to make sure it was clear.
Yes, sir.
Because sometimes when that happens in a written transcript, it's not as obvious as to what you're saying.
Yes,
So
sir.
that's why I try to make sure the record's clear by saying stuff like that. All right. I just don't know what you really want me to do here, Mr. Carroll. You just seem to you disagree with your lawyer on things. You claim you filed a civil lawsuit, but I don't see one anywhere.
I mean, I mailed it back to her for her to file. Waiting on her.
Okay, well, 'cause that's the only thing that's brought up in your Nelson hearing. Nothing about disagreements with your lawyer. So, I mean, if one actually gets filed, I'll readdress it. But from what I heard today, I just don't see a reason.
Honestly, he just like.
I mean, based on the fact that you've interrupted me now 3 or 4 times, I'm just not sure what you're claiming he's doing to you. Anything else, Mr. Carroll?
I just really want him off my case.
I understand, but you have to tell me what he's done that's been ineffective. You don't get to just choose who your attorney is when the one gets appointed.
You told me last, Nelson Heron, that it continued to be a conflict between us to come back.
And that's what we're here for.
And it's continuing being a conflict between us.
I understand that, but you haven't told me anything that he's done wrong at this point.
Well, I mean, it's not right for him to be able to talk to me any kind of way and treat me like trash. I mean, when you're sitting there yelling at me and I'm talking to you like a normal human being because you get mad because I asked you to do something.
Mr. Russell, anything else?
Judge, I don't remember yelling at Mr. Carroll, and I've been doing this long enough that I don't get mad very often. So if he wants me to reset the bond reduction hearing in spite of the other things that we discussed during our conference, I will be happy to set it.
We already discussed all that.
Okay, do you want to set it or not? Yes or no?
Point in it. I'm not signing no deals. I'm not.
Understood. The other issue that I have, Judge, is that I have depositions scheduled in the case right now for October the 20th. If this lawsuit comes to pass, I don't know what to do with the depositions. I don't want to mess it up if the court finds that I should get off the case. I don't want to mess it up for the attorney that follows me. I don't know if I should cancel those depos for now and see what happens.
I just, until I see a civil lawsuit that's actually being filed, I don't have any evidence of it.
Okay.
I know you're saying that's going to happen, but I don't know what your lawyer has received. Has she gone through it? I mean, I'm familiar with Ms. Maddox. I've had hearings with her twice this week on civil cases because I handle the civil division as well. So it's hard for me to do anything until I know a suit's been filed. So I'm going to deny your Nelson hearing, or your Nelson motion at this time, Mr. Carroll. I'm going to say the same thing I probably said to you last time is, if there's some new issue, I'll certainly address it. If a lawsuit's actually filed, I'll address it. But from what I've heard at this point, I don't think you've told me anything that Mr. Russell's done that would make him ineffective. We're set for pretrial conference on October 29th at 9 a.m. Obviously, if that lawsuit's filed, I mean, you maybe even indicate to Ms. Maddox to give my office a heads up that it's been filed, and I'll take a look at it, and we can address it as soon as possible. Or if you want a bond motion like y'all just discussed, if there's another reason to consider a Nelson inquiry, I'll certainly do so. All right, thank you, Mr. Carroll.
And I need to see him in the back for a second before he goes back, and then I'll come back there and talk to you in just a second. Last case on the docket that I have, judges, John Beagles, case number 21 CF 2135, 24 CF 27. Mr. Beagles was previously found incompetent and unrestorable by the court. Mr. Sheik is attempting to reach the alleged victim in the 24 case, and that may lead to some kind of resolution on the cases. Okay. So today, I'm just asking for continuing the case till October the 9th at 9 to give the state some time.
Accurate.
And yes, Your Honor, and the state has reached out. We're just waiting for the response back, and then we'll probably call again.
Okay. All right, October 9th at 9 o'clock.
Thank you, Judge.
Is that the last one for you, Mr.
Yes, sir.
All right. Can we take about a 5-minute break? All right. Thank you. All rise, please.
We're open Saturday 10 to 4, Sunday 10 to 3, and at both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Darian Terrebonne, November 12th, 1988.
Okay, ma'am, you're here in 24 CF 2695 for a violation of probation. You understand that?
Yes.
I've been given a plea agreement between you and the state that would have you admit to your violation. You be adjudicated guilty, reinstate probation with the same previous terms and conditions with the addition of 20 hours of community service, $100 court costs or VOP fee, $100 PD fee, and a $50 application fee. Continue to waive cost of supervision. Is that what you want to do today?
Yes, sir.
All right. Did you go over this plea agreement with your lawyer?
Yes.
Did you understand and sign it?
Yes.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by making an admission to your violation of probation, there won't be an evidentiary hearing where the state would have to prove that you violated your probation?
Yes, sir.
You understand that you're waiving all potential defenses that you may have to your violation?
Yes, sir.
And this is state's agreement?
It is, Your Honor.
Okay, and Ms. Terrebonne, what is your plea to the violation? Is it a admit or deny?
Admit.
All right, let me accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, reinstate probation, same terms and conditions as previously ordered for you to do. New condition of 20 hours of community service, $100 court costs, $100 PD fee, $50 application fee, waive cost of supervision. Was she previously adjudicated?
Your Honor, I don't believe so in speaking with her, so I did talk to her about what it means to be a convicted felon. I also explained that because the original underlying charge was a drug charge, that would trigger a driver's license suspension, and that she would need to provide proof of counseling or have a 6-month suspension. And either way, she would need to make sure she goes to DMV to see about reinstatement.
Yes, ma'am.
Just want to make sure you understood all that. So, Ms. Terrebonne, I'm going to have you talk to probation. I also need you to be fingerprinted up front because it is an adjudication now.
Okay.
And then you'll have 30 days to appeal your judgment and sentence.
Okay.
All right, thank you.
Thank you.
Oh, the probation's probably going to want to
Probation
talk to you.
first, sorry. I think I said that, but I might have not.
Your Honor, I just need to go over an offer with Mr. Perry real quick.
Okay.
Your Honor, this is Richard Perry, 24 CF 1303. We've reached an agreement in this matter, if I may approach.
Yes, please. All right, Mr. Perry, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
So this was a misdemeanor originally?
That's correct, Your Honor.
Okay, just because there's no score sheet, that's what I was
That's
asking.
correct.
Gotcha.
Mhm.
Thank you. Mr. Perry, you're here in 24 CF 1303, where you're charged with a violation of probation on a misdemeanor case, even though this is felony court. I've been handed a plea and sentencing agreement that would call for you to admit your violation. Is there an adjudication already?
I would imagine so, Your Honor.
There is, but just the box wasn't checked. I just want to make sure I
Sorry.
had that right. All right, so Mr. Perry, if you admit your probation, would be a revocation, and terminate your probation. 120 days Okaloosa County Jail, credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Should it be a $100 PD fee if it's a misdemeanor?
Oh, that's correct, Your Honor. All of it should be $50. $50 PD fee, $50.
So it would be a $50 cost of prosecution, $50 PD fee, $50 application fee.
Thank you.
Just saved you $100.
Thank you.
Okay. Is that what you want to do today, Mr. Perry?
Yes, sir.
All right, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
All right, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
You got a big smile on your face, Mr.
Yes, I
Perry.
do.
Okay. Do you understand that if you admit your violation of probation today, that there won't be a hearing where the state would have to prove that you violated your probation?
Mm-hmm.
Yes?
Yes, sir.
No, I just want to make sure it's clear. All right, and do you understand you'd be waiving any potential defenses that you may have to your violation?
Yes, sir.
All right, and what is your plea to the violation of probation? Are you admitting or denying?
I'm admitting.
I'm going to accept your admission to the violation of probation as freely, voluntarily, knowingly given, revoke and terminate your probation, 120 days county jail with credit for time served, $50 cost of prosecution, $50 PD fee, $50 application fee. What I'll do, Mr. Perry, is allow you to have 60 days from your release to go ahead and get a payment plan set up or pay those court costs. Otherwise, it'll be a judgment.
Yes, sir.
Okay. Anything else from Mr. Perry?
No.
All right. Thank you, Mr. Perry.
Have a nice day.
Your Honor, this is Pablo Portugal before the court on 21 CF 748, 21 CF 749, 21 CF 750. We did just receive the plea offer and score sheet from the state. We are going to request a continuance and ask for the October 30th court date with no subpoenas.
These all VOPs?
Yes, Your Honor.
Okay. All right. You understand that, Mr. Portugal?
Talk about it.
You understand that? We're going to put on
Yes, Your
October
Honor.
30th?
Yes, Your Honor.
All right, October 30th, 9 o'clock, no subpoenas.
Okay. Your Honor, he is still, so that's Sean Ruiz, 18 CF 1056, 18 CF 1381, 18 CF 1450. Your Honor, we had spoken about this last month. Over in Santa Rosa, Santa Rosa had him transferred over there to address a court case over there, and he's still over there. So we would just ask for continuance.
Do we need to
October.
do an order to have him come back?
I will check into that, Your Honor, if the court's willing. I will see about doing that.
You know if his case has been resolved?
Well, that's just it, Your Honor. I haven't had an update. Last time I had an update from the attorney who said just had a new case that they hadn't addressed. They'd addressed one, but then another one popped up, and they were going to try to address it. I doubt that they've been to trial yet on it, so I would just ask to put it on for October 30th, and I'll see what I can find out. That's over in Santa Rosa.
He still has a misdemeanor open over there, his court on November 6th.
So, Your Honor, if we could put it past October 30th then? A November date?
Do November 6th. Problem is November 6th, that's the day he's got court there, is our miscellaneous date, and then I've got 2 trial weeks, the 13th, and so those next 2 Thursdays are criminal trial weeks, and following Thursday after that is Thanksgiving. So how would you like to handle that?
Your Honor, if we could put it then on the December date?
Why don't we put them on October 30th just to kind of see where we're at that point? Maybe they'll resolve it earlier. But if you look into it and nothing's going to happen before then, just file a motion to continue it. I'd have to go figure out what my December dates are.
Okay.
Or we can potentially, squeeze it in on a different date once you know what's going to happen with it.
Yes, sir.
All right, October 30th at 9.
Your Honor, this is David Smith before the court on 21 CF 590. Last time we were in court, Mr. Smith had asked me to check into some things that involve Court Smart. I did. Unfortunately, the Court Smart that we got was broken off. The recordings were broken off. So there's an issue with that. I'm going to have to re-request Court Smart for that. So I'm going to ask for court to be continued to October 30th, and that would be with no subpoenas. And this is Ms. Basso's case. I did talk to her about that yesterday, or day before, Monday, one day this week, Your Honor.
October 30th at 9 o'clock, Mr. Smith. We'll see you back that day.
Uh-huh. Your Honor, this is Mr. Stone, if I may have just a moment with him.
All right, what would you like to do, Ms. Rivers?
Your Honor, Okay, all right. Your Honor, I did want to convey the last offer by the state. His case number is 24 CF 2274. We're going to set this matter for a contested hearing at this time. And this case is Ms. Basso's.
When would you like to set that? State have a preference?
No, Your Honor, not particularly.
You want to have the October 9th? Is that enough time?
If I may ask, Ms. Rios, because I'm not familiar with the case, does this involve a new law violation? No. So probably the 9th would be fine.
Okay.
October 9th at 2 o'clock for a contested VOP hearing
And I'll be back out to see you.
with subpoenas.
Your Honor, this is Tony Tatum before the court on 20 CF 1826, 20 CF 2406. Your Honor, we previously had a hearing regarding the motion to correct sentencing errors under Florida Rules of Criminal Procedure 3.800B2. Based on our last court date, it was determined we did need to have him brought here for the resentencing process. And if the court will recall, he is entitled to credit of 748 days. There was also that there needed to be corrections to the score sheet in two different areas. One had to do with where the DUI was listed on the score sheet, and then the other had to do with the status of listing him as a violent felony offender. So, and I did meet with Mr. Tatum yesterday at the jail. Mr. Tatum does disagree that onto the amount of jail credit that he's entitled to. He believes he is entitled to a significant amount more, and he is asking the court to give him credit for
It's in my other paperwork that they ain't give me.
So, Your Honor, he indicated to me that when he originally went to jail on this first case, the 2020 cases, that he did not get out of jail, that he was there the whole time, and he eventually pled to get out of jail. And that's what he had indicated to me yesterday, and that he had like 18 or 19 months credit at that point, plus each and every time after that, he had additional credit. Now, I did look on the clerk's website, and it is different. And I am going to hand that to him. So it shows right here that you had an ROR bond. And then this will show the date where they did an order revoking the bond and commanding your arrest. And then it shows where you got rearrested. So you weren't in the whole time. And then it says the reason you were rearrested was for never reporting to pretrial services. So this is saying that you did get out. Saying that you said you posted your ROR bond on 10/18/21. The judge revoked your bond on 6/10/22, and then on the 7/11/22, you were arrested again on that case. So during that time, you wouldn't have been in jail. And so I gave you this so you can look back over that. Okay?
I'll just point out the motion says should be corrected to provide 748 days credit. So if he's asking for more than that, I don't think I can give him something he didn't ask for in a motion.
Well, and Your Honor, I just wanted to make his position aware, and then I did want to indicate to him what I was able to find on the clerk's website, showing.
Well, I think the issues, if I'm not mistaken, Number one, he was given, when he pled initially, he was given, there was a stipulation that he had at least 15 months credit. Turned out he didn't by 20 days or something, 25 days. I can't remember the exact number. And so when we were here last time, you weren't here, Mr. Tatum, but I think we all talked about it and said he's entitled to 450 days because that's what the stipulation was back then. So you get all of those days, even if you didn't actually have the credit, because that was part of the order back several years ago, I think. Or maybe was it just last year? Can't remember which year it was, but that was the issue that gave you more days. But I think one of the concerns that you may have been asking for some credit that occurred before you were even arrested on the latest case. Am I getting that wrong?
Well, Your Honor, what he was saying is that when he was originally arrested on 20 CF 1826, 20 CF 2406, he was saying that he never bonded out, and that the first time he got out of jail was when he pled to the charges. But I was giving him some paperwork that was showing different.
Yeah, because when I was in there, I pled to the charges. Then they, see, it was the same charge in Santa Rosa County too. So Santa Rosa came and got me what they let.
But I don't have any control over what credit they gave you in Santa Rosa.
And, Your Honor, it does allege in the motion 748 days credit that he's entitled to on both cases instead of 732 days and 731 days. So we would be asking for that additional credit. Also, the score sheet, the math was done incorrectly on that, and so there was an error there. The points should, instead of being permissible sentencing of 53.775, it should have been 50.775. So we're asking for the correction there. And then, of course,
I think I went back at some point and went and reviewed that. It wasn't me that was there that day, because the issue is, did the judge sentence to the guidelines? And if the guidelines have been different, would the judge have still given a guideline sentence? Again, it wasn't me, so I can't really, go inside that judge's thought process. But I don't believe anything was said as far as that there was any discretion or that the judge was doing something in particular that had to be 53 point whatever months. So I think that ultimately, pretty much the agreement is that he would get what he scored, which is about 3 months less.
So
it means you're going to get additional credit. Goes from 53 down to 50 months.
But I get out, like, even I get the 700.
Yep, you get 747
plus our
days.
days, plus the days for the DUI statement and all them. I get all of them days.
The DUI, not days, it's just his argument was where it is on the score sheet was wrong. This motion says where it was on the score sheet was wrong, and that it has to be moved to a different, it can't be moved, it can't be down as a prior, it has to remain up there as a current. So that part doesn't really change your points any. And then the last issue was violent felony offender of special concern designation in the score sheet, which that also would have to be changed as well.
Which is what got it down to 50.775.
That would double my points anyway. Because I ain't score out to nothing. I was like 20-something points before y'all did that.
So it doesn't erase your points, it just puts it in a different block on the score sheet. Still get the points for violation of probation, just doesn't do it as a violent felony offender of special concern.
Yeah, but I only violated my probation for this so-called new charge that I didn't catch.
You violated your probation. You were arrested for a VOP back on December 18th, 2022. Then you were sentenced in February of '23. You were arrested again for violation of probation on March 6th of '24. You admitted to your second VOP on June 18th, 2024. Then you had this one, the third one, which was based on the felony that ended up getting dismissed. But you also had other issues with it, so instead of being a 12-point violation, it would be a 6-point violation. Third violation, so each violation you get points.
Hey, but you only violate me on the. You only violate me on the last so-called charge that y'all so-called say I violated for. So
you would get 18 points. 6 points for each violation
Instead of 36.
instead of 36. So that would have to be corrected as well if it lists more than 18 points. It would have to be corrected to be 18 points.
So it should not even be violated. Like, because the so-called charge y'all violate me for, I ain't never get charged for.
So
Or you entered a plea.
No,
I ain't entered no plea. I
Actually,
did
we
not.
had a contested
You had a
VOP
contested-
hearing.
In front of who?
You.
You, Your Honor.
It was me?
Yes, Your
What
Honor.
date was that?
We had a contested.
February 6, 2025.
We had a contested VOP hearing, and the court found him guilty based on a 911 call.
Allegation.
'Cause every other piece of evidence was hearsay.
Which is allowed.
Denial.
So he didn't do anything incorrect.
Yeah.
Even a 911 call was hearsay, so.
But it was allowed, he provided the case law on that,
I mean, you're free to appeal that.
which he is, Your Honor.
I understand, but the 3,800 is just to kind of fix some of these other things as far as your credit and the score sheet. But you can still proceed with your appeal, Mr. Tatum. Sorry, I mistakenly said it was a plea. I was thinking of the plea in front of the other judge previously, so that's my mistake. So the whole point of the 3,800 is to correct the sentence based on the score sheet issues and the credit issues. Once those are resolved, you'll proceed with your appeal.
I thought it was the appeal. I didn't know.
Just sometimes the appellate lawyer wants to clean up the record and fix some of these types of issues before the appeal goes in, because basically that's how you're supposed to set it up for the appeal. I don't really want to give you any advice on that. I'm just trying to give you information as to why that's done this way first.
Yes, sir.
But this doesn't prevent you from pursuing your appeal on the VOP determination.
Yes, sir.
If you go forward with the appeal and the District Court of Appeals says I was wrong to found that you have violated your probation, then we'll come back and deal with it at that point. Anything else?
No, Your Honor.
Is your appellate counsel, is he going to send over an order, or are you going to send over an order on that? Because I mean, if he scored 50.775, is that what everyone thinks is the right score based on the change?
That's correct, Your Honor. That plus there would have to be an amended judgment and sentence to reflect that he is to get 748 days credit.
Instead of the seventh, it says 731 here.
Yes, Your Honor.
So it's 17 more days credit.
Yes, Your Honor.
And about 3 months off of the sentence.
Yes, Your Honor.
That's fine, Your Honor.
Okay.
3.5 months.
And Ms. Leone, y'all going to do the amended score sheet?
Yes. As soon as the order comes through, I'll provide the score sheet.
We all agree it's 50.775.
Yes, Your Honor.
Yes.
Oh, shit, 2 seconds.
Yes, Your Honor, I will submit the order. Of course, I will CC Ms. Leone.
Anything else for Mr. Tatum?
Oh, Your Honor.
Again, Mr. Tatum, I apologize for my mistake.
Not
on
at the
BOP.
moment. I still got to go back and look over, make sure I ain't missing nothing myself.
Say
'Cause I
again?
got it. I said not at the moment. I'm gonna go back and make sure I ain't missing nothing myself, because I had it looked over and run. Well, she
Well, I
gave
can
me-
only do what your motion asked me to do.
Yeah,
I think I've pretty
I
much done
understand.
everything that your motion has asked to be done.
I understand. Thank you.
All right, thank you, Mr. Tatum.
Your Honor, if I may have a moment with Mr. Thomas to convey the offer by the state. Your Honor, this is Russell Thomas before the court on 22 CF 776. We've reached an agreement in this matter. Every time you've been in on this case.
Okay.
Mr. Thomas, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
So Russell Wayne Thomas, it's 8/13/1970.
I think you gave me a stack of the PD forms, the application. Like, what is all this? Let me make sure that's the last one. All right, Mr. Thomas, you're here in 22 CF 776, where you're charged with a violation of your probation. I've been handed a plea agreement between you and the state for you to admit your violation, adjudication of guilt, revoke and terminate your probation, 7 months county jail, credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Is that what you want to do today?
Yes, sir, I do.
Did you go over this form with your lawyer?
Yes, sir, I did.
Did you understand and sign it?
Yes, sir.
And are you satisfied with your lawyer's advice and representation?
Absolutely. Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering an admission to your violation, there won't be an evidentiary hearing where the state would have to prove you violated your probation? Because you're admitting it, you understand there's not going to be a hearing?
Yes, sir.
Okay. And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
Any objection to the score sheet, Ms. Rivers?
No, Your Honor.
Okay. Score sheet shows 34.2 points, so this is a guideline sentence. All right, Mr. Thomas, what is your plea to the violation of probation? Are you admitting or denying it?
Admitting, yes, sir.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given. Revoke and terminate your probation, sentence you to 7 months in the county jail, credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Was he convicted on the underline?
Yes, Your Honor.
Okay. So we won't need his fingerprints. All right, you've got 30 days to appeal the judgment and sentence of the court, Mr. Thomas. Otherwise, you're ready to go. Thank you.
Your Honor, if I may have a minute with Mr. Truelove.
Okay.
Your Honor, we're going to ask to reset this for October 9th.
Okay. It was intended for a plea today, right?
Yes, Your Honor.
I just want to make sure it has what dates it also has.
Yes, Your Honor.
Okay.
But he submitted me 2 pages of things to go over.
Sure, that's fine. I just wanted to make sure we have a pretrial date as well.
Want to, I don't know.
You can, but just understand everything in this room is recorded. You might want to run by whatever you want through your
I may
attorney.
want to bring it up later with you once we've gone over it and over the legal work that I brought to her and everything.
All right, October 9th at 9 o'clock. Is that for a potential plea? What are we saying?
For a potential plea, or we will go from there. I just
Otherwise-
really can't say anything at this point.
I understand. Otherwise, October 29th
Yes, Your
at
Honor.
9 o'clock for
For the
pretrial
pretrial
conference, which
Yes,
is
Your
already
Honor.
set.
Yes, Your Honor.
All right, thank you.
All right.
Thank you, Mr. Oberliesen.
Get back out there, Chase, see you.
Your Honor, can I call Bradley Anderson?
Sure. Well, who else has inmates? Oh, just you, okay. Go ahead.
Your Honor, this is Mr. Anderson. He was placed on today's docket. The state had made Mr. Anderson an offer that expires at the end of this month. I have reviewed the files with Mr. Anderson. He is aware that he is looking at a potential 24-month. I mean, the state's current offer is 24 months. The score sheet is 23.8 months and change. He is insistent that he did not commit this fleeing charge. I have explained to him that's fine. We have depositions in progress. He is rejecting the state's offer at this time, but he is aware that this is almost certainly going to result in a trial here. So we are moving as quick as we can for the state's benefit. Ms. Leone, at some point, probably today or tomorrow, you're going to see an amended witness list. We're listing.
I saw it.
Okay.
There was one witness.
Okay, so we're adding a witness. There might be a deposition of that witness. So, but he is aware that the waters he's in right now. So, If we can leave them on the October 27th pretrial docket, and we'll take it from there.
All right, Mr. Bradley, you understand all that?
Yes, sir.
You understand that if by rejecting the offer, the state's announced, or hasn't announced, but your attorney said that they're
Yes,
going to reject it, or take it off the table?
Yes, sir.
Okay. All right, and let's go October 29th at 9 o'clock.
27th, Your Honor?
27th, I'm sorry, you're right.
I'll see you on the 20th, though. You have court with Judge Ward. Okay. Then I just have inmates, Your Honor.
I may, Your Honor, quickly, Corey Kreider, he believed he was on the docket today. I see that it's been canceled. It was a previous pretrial intervention agreement. Today was just a status date, 25 CF 177, when you get a second.
Has it been filed?
Yes, Your Honor, it has.
You'll verify Corey Kreider. It sounds like it's been filed, so we'll take it off the docket.
Okay.
Thank you, Mr. Kreider.
Let me see that.
Hello, Your Honor.
I want you to sign there and there, there and there. Here's a pen. Today is the 25th. Your Honor, Mr. Stewart is executing a plea agreement to resolve the 3 cases that he has before the court. At this time, Mr. Stewart would withdraw his previously entered not guilty plea in 22. Today's 9/25. Sign that one. In 23 CF 2380, Mr. Stewart would be entering a no contest plea as charged. The agreed upon disposition in that case is that Mr. Stewart would be sentenced to 37.2 months in the Department of Corrections. The state will stipulate that that entire sentence has been served. He would be assessed $615 in court costs, $150 for the cost of defense. He has previously been adjudicated in 22 CF 1397 and 23 CF 754. Mr. Stewart would admit the violations of supervision. He would also be sentenced to 37.2 months in the Department of Corrections on those, concurrent to the sentence in 23 CF 2380. The state will stipulate that that entire sentence has also been served. Those 2 supervisions will be revoked.
Can I ask a question?
Yes, sir.
37 months is over 3 years, right?
Yes.
And these cases are from 2023.
So the 37 months is for the first case, and I apologize, that should have been, so we would be fine with
coterminous?
Coterminous, Your Honor.
Oh, there's a 2022 case.
Yes, you're correct.
Okay.
What does
I just want to make
coterminous
sure we don't want to have to come back and fix it later.
Okay.
All right.
The state is stipulating that he has sufficient credit.
I
And it'll be
reviewed,
coterminous as well as concurrent.
yes, Your Honor.
Okay.
And I have reviewed, and the state has a genuine belief that he is over 37 months.
On the first case.
On the first case, yes, Your Honor.
The supervisions will be revoked and terminated in 22 CF 1397, 23 CF 754. Mr. Stewart would be assessed a $100 cost of prosecution for each of those cases, plus another $200 for cost of defense. He has previously been adjudicated. I did talk with Mr. Stewart, and he does want to try to make these court costs payments.
Yeah, I have the money to pay them.
So I will ask the court to give him 90 days to set up a payment plan with the clerk's office.
Yes.
That mean I need to get a ride home today? Okay. I'm also set up with Miss Mary Plitt as my case manager from Bridgeway to continue my meds.
I'm just looking at his credit just to see that we're close to that, so there's not any further issue down the road. All right, Mr. Stewart, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Isn't there 3 case numbers?
Yes, Your Honor. There's, 23 CF is a new charge.
Oh, he did a separate.
Oh,
Yes, Your Honor.
Okay.
Yeah, sorry.
All right, can you state your full name and date of birth, please, Mr. Stewart?
Chase Brandon Stewart, 7/1984, sir.
Okay, and Mr. Stewart, you are here on violations of probation in 22 CF 1397 and 23 CF 754.
Yes, sir.
As well as a new charge of tampering with evidence in 23 CF 2380. Do you understand all that?
Yes, sir.
All right, and I've got 2 different plea agreements. Did you go over both of them with your lawyer?
Yes, I did.
And did you understand both of them?
I believe so. I believe I'm being released today.
Well, I can't say that. Did you understand everything in here, not just about if you're going to get released today?
Not really, but yes. And
Well, then we got to ask you some questions. What did you not understand, Mr. Stewart?
I just don't understand the 37.2 because I've done 1129 on the case and I've done 22 months, including, and 5 months. I guess it adds up
Okay.
in the plea agreements.
Rights you're giving up.
Did you have any questions about the plea agreement?
No, sir.
Right. And did you sign each of the plea agreements?
Yes, Your Honor, I did.
Okay. Are you satisfied with your attorney's advice and representation?
I am satisfied with my attorney's advice and representation.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
I have schizophrenia, sir.
Okay. But we went through the competency issue, and
Yes,
you were
sir.
found to be competent
I am
today, right?
competent.
Okay. And did you spend some time in the hospital for that?
Yes, sir.
Okay, and then you're in your back, and they say that you're good to go, right?
I'm good on medication.
Okay. Just want to make sure. You understand what's going on here today?
Yes, sir.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
On the violations of probation, do you understand if you admit your violation of probation, then there won't be a hearing where the state would have to prove that you violated your probation?
Yes, sir.
And on the new case, the tampering case, do you understand that by entering a plea of no contest, that there won't be a trial of any kind?
Yes, sir.
And that you're giving up your trial rights, which are on the form that you signed?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have to the VOPs or the new case?
Yes, sir.
And do you understand that if you're not a U.S. citizen, you could be deported because of these cases?
Yes, sir.
And I looked at the guidelines, and this is a guideline sentence of 37.2 months. Do you understand that the conditions of your plea are that you'll be sentenced to 37.2 months in the Department of Corrections, and the state is stipulating that you've already served your entire sentence, as this is going to run concurrent and coterminous?
Yes, sir. What does coterminous mean?
It means all of the cases will not only run at the same time, they'll end at the same time.
Okay.
Otherwise, from my looking at it, you may not have enough credit in the old or the newer cases.
Right.
But because the state's agreeing that you can have credit on all of them, they'll be coterminous.
Okay.
Then they'll run all together and end together.
Okay.
And the state's stipulating that you have the credit for the entirety of that time.
Yes, Your Honor.
Okay. Then I'll revoke and terminate your supervision in the probation cases, be a $100 cost of prosecution, times two, $200 cost of defense.
How do I pay who do I pay it to?
We'll get to that.
Yeah.
615 court costs on the new case and another $150 cost on defense there. Just want to make sure you understand all the terms.
Yes, sir.
All right, on the violation of probation, are you admitting or denying your violation?
I'm admitting.
Okay. And on the new case, the tampering with evidence, third-degree felony, what is your plea to that?
No contest.
All right. I'm going to accept your admissions to the violations of probation in 22 CF 1397 and 23 CF 754, as well as your no contest plea in 23 CF 2380. On each case, I'm going to sentence you to 37.2 months Department of Corrections, The state has stipulated that you have served that entire sentence, that your sentences will run concurrent and coterminous. In the VOP, it's going to be $100 cost of prosecution and $200 cost of defense. In the new case, 23 CF 2380, $615 in court costs and $150 cost of defense. Again, this is a guideline sentence. I'm going to give you, from your release, 90 days to pay your costs
Okay.
or set up a payment plan.
Yes, sir.
You understand all that?
Yes, sir.
Okay. Anything that I've missed?
No, Your Honor.
No, Your Honor.
For Mr. Stewart's benefit, you're going to go to the clerk's office downstairs.
Oh, okay.
Okay, so when you're released, come back to this courthouse.
And go to the clerk's office?
office, and they will help set up a payment plan for
Okay.
you. Okay?
All right. And what does that total come out to be approximately? Okay.
Honestly. New costs are going to be.
$915 and $1,065, give or take?
Yes, sir.
Plus whatever you may still have outstanding from your violation cases.
Okay.
If there's still court costs that you haven't paid yet for those,
Okay.
it's going to be 1,000 plus whatever.
Okay.
is there. But the
All right.
clerks will be able to give you.
Yes, sir.
full amount.
I like your glasses, by the way.
Well, thank you. They're rapidly failing me.
All right. Mr. Stewart, I'm going to need you to be fingerprinted, and then you'll have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
All right, thank you, Mr. Stewart.
Thank you.
All right. Your Honor, this is Ricardo Bryan. So I met with Mr. Bryan yesterday, and he's in the process of putting together an amended motion for a new trial. Primarily the benefit for myself and the state and Your Honor, he's actually making specific references to the record in the amended motion. So I'm going to meet with him early next week. I'm going to ask.
It's like a 600-page transcript or something like
100%.
that. You told me, I think, last
So he was showing it to me yesterday, and I said, that really helps. So I'm going to meet with him early next week at the jail. He hopefully will have a completed copy so I can take it and get it over to Your Honor and the state. I would ask the court to continue this to the October 30th date. I'm moving as quick as I can. I know Mr. Bryan has a copy of the transcript of the sentencing proceeding too. I'm trying to get my hands on that as well. And I have asked for Court Smart, if it still exists, of the sentencing proceeding so I can actually watch what happened since I wasn't here.
What was that date?
I believe it was December 9th, 2021, I believe. So
I would guess they'd still be able to.
I think it does.
Find it. It'll just be archived, so they'll probably have
Correct. So
it'll
we're-
probably take a little longer for them to track it down for you.
as soon as I get my hands on that, I will file it in an amended discovery, and we're tracking, we're moving it as quick as we can. So we would ask the court to continue this to the October 30th date.
In my experience, anything that happened before the September 23 cybersecurity issue, I can't access unless I ask them for it. So that's just make your request so they can get to it, because they might have to, go into the archive to find it.
And so I don't know if Mr. Bryan is aware, in 2023, there was a cyber attack on the First Circuit, so it kind of caused a lot of problems. That's what he's referencing, okay? So if we can continue this to the October 30th date, I'll see you early next week. Okay.
All right, October 30th, 9 o'clock, Mr. Bryan.
Thank you. All right, have a good weekend, okay? All right. Your Honor, this is Mr. Fell. I have had a chance to review, is this for me? Yes. The Gould opinion. I'm going to call it Gould, just.
I think that's how you pronounce it.
In all candor, it's probably one of the most monumental DCA opinions I've seen in maybe the entire time I practiced. I mean, yesterday when I met with Mr. Fell, he gave me a raft of new authority he wants me to read. For that reason, I need to ask to continue this to the October 30th date. There's quite a bit of case law that he has given me, and Ms. Barrickman has been in trial, so I really haven't even, I don't know what her position is on any of this. So I would ask, and this goes to Mr. Bryan too, if the court could order that Mr. Bryan and Mr. Fell remain in custody at the Okaloosa County Jail pending their next court date. But I would ask for the 30th.
I think if you can send me a written order on that.
I'll get you one.
because
I'll get you one
if
today.
the clerk's minutes say that, it may not.
I know, show up before they get, we'll get you one today. But if we could continue into the 30th too also, this is I think going to be probably a complicated legal argument. And the state stipulates to something, I don't know, but.
I mean, I think I know how the argument goes, but it just depends on what the state's going to.
100%, so.
Because I think I told you this before, Mr. Kleins, I had another issue that was related to this. I wrote a pretty lengthy.
What was the
order
name
on
of that again? I had written it down.
Laggett.
Laggett?
Laggett.
Laggett.
Let me I'll give you the case number. Hold on.
Yeah.
Because I've got the order saved in my. 2012 CF48.
CF48. Okay, I'll review that also. I mean,
It explains my opinion on the Gould case, and obviously this is for the state too. I think we've talked about it when Ms. Barrickman was here, but obviously the state was part of the argument, I believe. But it explains the Gould case issue, and let's see. And I don't remember all the details of Mr. Fell's case and how it fits into her time-wise and things like that, because after Gould, there was Florida legislature passed a new bill that would have kind of closed this, I don't want to call it a loophole, because that makes it sound like it's something less than what it actually is.
Right.
But it closes this issue out going forward, which I think is for sentences imposed after July 1st. But again, I'll take a look at that.
I kind of chuckle because we were actually talking yesterday about how I'm surprised the legislature hasn't responded to this yet.
Oh, they did.
Oh,
to the Gould case, in the next session, I think Gould came out in, say, October, and they got it in March or April or May, whatever it is, the following year.
Not retroactive, so that's all I care about.
Yeah, and so it all just depends on the dates, and
Okay.
I haven't explored that particular issue yet.
Certainly. I will review the Laggett opinion and get a copy of that to Mr. Fell.
Well, Laggett's really not an opinion, it's my order in a somewhat similar issue.
It's your opinion on the ruling.
Still relevant. My order is an opinion on a ruling. Okay.
So if we can continue him to the October 30th date, Your Honor, we're working toward getting this set up for a hearing too.
Okay. October 30th, 9 o'clock. Make sure if there's any other case law you want me to read before then, send it
Absolutely.
to my office.
Oh, absolutely. So, all right, I'll come talk to you. So one of the things Mr. Fell wants me to address is the court has construed his motion as an A motion. He filed it as a B motion. I told him I would look into that. It was the first I'd heard of it this morning. So that's something that is on the radar for sure. And I haven't seen that, so I said, all right, well, let me look into it. I mean,
We'll address it on that day.
yeah, that's kind of what I
Now, if there's any supplemental or memorandum you want to send over, I'll read it in
Yes, sir.
advance. All right. Thank you, Mr. Fell. We'll see you back on October 30th.
Your Honor, we have Miss Cecilia Mortimer. We had her transported over today. She's not on the docket, but she is present to resolve 25 CF 243, which is a grand theft auto. Yes, sir. This is your copy. That's your copy. He's not going to do that. I'm just trying to get you out today. I need you to sign and take this right here.
Did you get a case number?
Today's 9/25/25. I'm going to take this staple out so you don't get in trouble with them before they get out. All right, that's what I'm about to talk about. That is your copy. Gonna approach?
As part of this, Your Honor, I talked with Mr. Sheik, and he stated
So Ms. Mortimer was arrested last Thursday, on a misdemeanor battery. There's a $1,000 cash or professional bond on the battery. There's no bond on a misdemeanor VOP case. And I really appreciate Madam Clerk getting a case number, because an hour ago, we didn't have a case number. The intent is for Ms. Mortimer to be released onto probation in this 243 case while she has these new charge pending and the violation pending. I have instructed Ms. Mortimer that she's going to have future court dates for the misdemeanor case, and she cannot miss those court dates, and she has to report to her she has to report to her misdemeanor probation officer upon her release. So that was kind of the holdup, was we didn't even have a case number to have the order to reduce the bonds.
That's a new 25 misdemeanor case?
Correct. It's a 25 MM case. I don't know what the number is. But she's entering
That's
the plea.
the misdemeanor VOP case, which is 24 MM 3868.
Correct. And so if I could go over the terms of the plea agreement for the 243 case, Your Honor. Ms. Mortimer is going to be entering a no contest plea as charged. Count 2 is a first-degree misdemeanor, false name to law enforcement. That disposition will be time served. Count 1 is grand theft auto. Ms. Mortimer will be placed on 2 years of probation. She will pay $2,640 in restitution.
2 kind of looks like a 7, so I'm going to fix it to make it look like a 2.
Okay, please.
In my mind, I was thinking $7,600.
As I was writing some of these today, I was like, my 2s look kind of jacked up today. It's to Ms. Washington, I believe. There's 615 court costs, 150 costs of defense. She has previously been adjudicated, and the cost of supervision will be waived since she's indigent.
Mortimer, you want to raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Ms. Mortimer, you're here in front of me today. You can put your hand down. For 25 CF 243. We're not addressing those misdemeanor cases that were brought up. Do you understand that?
Yes, sir.
All
I
right.
believe so, but I will have bonds. I will have ROR bonds on those
Signature.
charges. Signature bond.
I don't know.
those
What is, are you aware of what's going on with the probation case? The
Yes,
24
sir.
MM 3868?
Yes, sir. I'm aware.
I see an order revoking her bond from Monday.
And
So I don't,
I was on.
Let me talk. I believe that the state, I think that the intent here is the state knows she's going to be on state probation. She's going to be reporting. Judge Ward is not in the courtroom, or courthouse, I should say, today. I think that, would the court entertain a signature bond on that violation?
I've talked to Judge Ward about accepting pleas in his cases as part of pleas in my cases, and he certainly is fine with doing that. But changing bonds or amending or modifying a bond without talking to him, I'm not sure that's something I'd be willing to do.
How about this? How about if we enter the plea for this? The court reduces the $1,000 cash or professional bond on the new charge, and then I will try to reach.
But it's an MM case.
Correct. If the court would.
I don't think I can change bonds on another court's case, another judge's case. I mean, if y'all reach out to his office and he's willing to do it, or willing to tell me to go ahead and do it for him, that's one thing, but
Understood.
I guess to reverse it, if another judge changed a bond in my case without consulting me, I probably wouldn't be happy about it. Mainly because I don't know the circumstances of their cases.
If we can enter this plea, Your Honor, I'm going to email Judge Ward and CC Mr. Sheik on that before I leave the courthouse today.
All right, and again, if y'all are able to work something out with Judge Ward or his office, and they just need a signature on something, I'm willing to do it once I
Sure.
get word from them that that's what
Understood.
wants done. But
The main thing that Ms. Mortimer is concerned about, she desperately wants to be at a sentencing hearing this court's going to conduct on October 9th. So that's one of the reasons why I'm having her before the court today, is to resolve this as quick as possible, because her bond was revoked in this case upon her arrest. So we're going to go ahead and enter the plea today on the circuit felony case, and we will reach out to Judge Ward, and if I can get him an order today, I will get him an order today. Felons.
So, Ms. Mortimer, I've already sworn you in. I just wanted to make sure you understood that I can't take care of the misdemeanor cases without approval from Judge Ward at this point. So do you understand that if you enter this plea, it doesn't change what's in the misdemeanor cases, but your attorney's going to continue to work on that for you?
Yes, sir.
Okay, knowing that, do you still want to go forward with this plea agreement? All right, so we're here in 25 CF 243. I have a plea and sentencing agreement that would have you plea as charged. On count 2, which is a false name to law enforcement, that'd be time served. On count 1, it'd be on the grand theft auto, 2 years of probation, $2,640 in restitution to Jessica Washington. That would be joint and several as her co-defendants, Mr. Klein.
There is one co-defendant. She has not pled yet, but if there is a plea.
Then it'd be joint and several for both. All right, $615 in court costs and $150 cost of defense. I would waive cost of supervision due to the fact that you've been found to be indigent. Is that what you want to do today, Ms. Mortimer?
Yes, sir.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you happy with your, satisfied with your lawyer's representation and advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Are you, or has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
And do you understand that by entering a plea of no contest, that there won't be a trial of any kind?
Sir.
And do you understand that you're giving up your trial rights, which are on page 1 and going on to page 2 of the agreement that you signed?
Yes, sir.
And you understand you're waiving all potential defenses that you have?
Yes, sir.
And I don't think I mentioned this previously, this would be an adjudication of guilt, so this would be a felony conviction on the grand theft auto. Do you understand
Yes,
that?
sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And any objections to the score sheet, Mr. Klein?
No, Your Honor.
So, and I'm showing 32 points on the guideline, so this is a guideline sentence. Probation?
Our records indicate she's on felony probation right now. In case number 24393.
That's correct, in Walton County.
Yeah, it's all Walton.
It's a Walton case. I think it was transferred over here. She's been instructed to report to probation immediately upon her release. Officer Collazo. I don't think.
Well, we don't have any information about her because she wasn't on the.
Yeah, Officer Collazo, I think, is her probation officer over here. So.
All right, just to make it clear for the record, it looks like on that case, she was placed on probation March 29th of 2025. This case happened in February, so it would have predated her probation.
That's what she was just advising me.
Out of Walton County, okay. Yeah, it's always good to put on the record. All right. All right, Ms. Mortimer, what is your plea to the grand theft auto and the giving false name?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. On count 2, adjudication of guilt, time served. Count 1, the grand theft auto is 2 years probation, adjudication of guilt, $2,640 restitution to Jessica Washington, joint and several with your co-defendant, $615 court costs, and $150 cost of defense. I'll need you to talk to probation. They're going to give you some reporting instructions, and then I'll need your fingerprints, and then you have 30 days to appeal the judgment and sentence.
And, Your Honor, when I email Judge Ward, I'm going to include Mr. Sheik, Ms. Flowers, and Your Honor. So, and I'm going to ask Judge Ward if he responds.
I just looked it up. It looks like he has a Zoom hearing this afternoon, so I would,
And I talked with the court. That's how I know he wasn't in the courthouse earlier.
I was checking to see if he might be in Fort Walton, because he often does things in Fort Walton, so, but all I see is a Zoom hearing this afternoon.
Sure.
But again, if Judge Ward or his assistant tell me they need this order signed on his behalf, I'll certainly do it.
Absolutely. Okay.
All right, thank you, Ms. Mortimer. Talk to probation. Is that it? I don't even know which pretrial detentions we have at this point. We got one of them that was set that was supposed to be a South End case, so we have to fix that.
Yeah.
But I don't have a bond on the vehicle. That's
Yes, I talked to.
It's the misdemeanor.
I communicated with Judge
Okay,
Stone.
but you shouldn't have any, you shouldn't even have to go back to Walmart.
Make sure it went down there. Because for some reason, they set it up here, but it's supposed to be a South End case. I think it was just a Scrivener's error.
So it's just a,
But he and I talked about it, so it should have been sent down there.
working as fast as I can.
Not gonna happen. Gotcha.
All right? All right, talk to them first. They're gonna talk to them.
Anything else?
That's all I had.
Yes, Your Honor, just one thing, very briefly.
Any more cases that are on the docket we can handle today?
It's for Tyler Webb, Your Honor.
Does he want to withdraw the plea, the second plea today?
No, Your Honor. The probation, no. Probation was just asking if we could do an order vacating the previous sentence, just to make it clear for them. That's how they'd prefer to do it. I just wanted to run that by the court and see if that would cause any issues for the court.
I don't have an issue with that. Just send me an order.
I will send that one as well. Yep. Thank you, Your Honor.
Anything else? They haven't done it in 2 weeks. Why would they do it today? All right, we're adjourned.
All right, thank you, Your Honor.
Well, I'm sorry. We're in recess until 12:30. I wanted to go home.
I'll try to use that 10 minutes wisely, Judge.
Oh, is it 12?
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backroom Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm attorney Kool-Aid Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Okay, then we'll be on recess until 1:30.
Thank you.
We're open Saturday 10 to 4, Sunday 10 to 3.